submits that although Osborne State Distribution Company has in principle agreed to provide the connection, it could not be effected due to resistance from respondent number 5 to 7. It is further submitted that the installation electric pole is required on a plot of land, which the private respondent claimed to be their own. That petition, however, disputes the claim contains that the relevant land is in fact a Panchayat road. Then when I cited that judgment, Sheikh Samad Malot, then your losses, then my lord, in view of first paragraph, in view of Rule 3B of the
26.
page 26.
Yes.
Licensing Rules 2006, I consider it appropriate to grant liberty to the petitioner to file an application before the concerned district magistrate for resolution of the dispute within 2 weeks from date. If such application is filed, the district magistrate shall consider and dispose of the same after affording an opportunity of hearing to the petitioner, the representative of such and such, and respondent of 5 to 7. They are private respondent. The entire shall be commented with such and such. Then, my lord, pursuant that direction, the petitioner submitted representing the next page. Then, you state your losses, can you see? My lord, page 36.
Yes.
That was the additional district magistrate, my lord, order. He served notice upon both the parties to make an inquiry. In compliance with the order dated such and such, such and such, in hearing was fixed on 24 June 2025. There was third paragraph. Whereas the petitioner submitted, the petitioner have a partnership business of packing drinking water or 20 liter per year and having trade license granted by the Pradhan of Gram Panchayat concern, they have existing electricity connection of 220 voltage, which they got in the year 2017, and they are running.
Yes, an alternative route was found, and there was a direction to provide electricity through the alternative route.
Then, my lord, the district magistrate page 38.
Yes, I have seen it. The
basis of the 39 can you see? 39. Hence, considering the
yes, I have seen it on the basis of joint inspection report through the alternative route.
And submit report to the district magistrate.
Yes.
But thereafter, nothing was done, my lord.
Yes, Mr.
Then, my lord, what happened?
There is an alternative route which has already
My lord, whole difficulty is this, my lord. We are being seriously restrained by the villagers. We have no objection. The route,
not the private response.
I'll direct police to be there with you.
Yes, my grievance was that the original route proposed.
No, the
alternative route.
Yes, yes.
Discovered,
Yes.
As such, I have no objection.
The petitioner complains of
Two, my lord, I am for the petitioner, my lord. My lord, theft by hooking, as
My lord,
usual, and my lord,
petitioner
final assessment made, no appeal.
own electric meter and paid electricity bill, but due to some accident or anyhow, the meter installed by the Minaka CCC has been burnt, and thereafter petitioner applied for new meter connection and paid the appropriate money to the concerned authority. But in the meantime, my lord, the Minaka CCC raid on the locality and also that petitioner's house that included in the raid. But totally arbitrarily raid, and there is no hooking in the service cable or tampering in the service cable. My lord, kindly appreciate that if there is hooking, that service cable must be tampered or.
Go and argue before the appellate authority. Where is the jurisdictional error? There is no jurisdictional error. How can you approach
My
the
lord, that
report?
arbitrarily that
Whether it is arbitrary or not, it is a factual thing, factual dispute.
but
Whether there is
in
a
the
hooking or
appeal,
not,
my lord, there is
been tampered or
my-
not, report will not intervene.
my lord, appeal in that there is problem is that petitioner is very poor person, but in that appeal, my lord, there is 50% in the
If you have an appellate forum, please go before that. If you have a jurisdictional point, you can argue. If you have an appellate forum before the writ court, what will the writ court do? Whether you have tampered or not, whether
my
wire
lord,
has been
kindly
used or
and
not,
my
these
lord,
are all
there
facts.
is main problem is that police has raid the local petitioner's house and trying to arrest the petitioner. My lord, kindly that appropriate
You have to take steps. What will the writ court do?
appropriate direction that there is no coercive action by the police, my lord.
By me.
In the meantime, I am trying to
You go approach the bail bench
Huh.
and take bail. I cannot.
in bail. Same is that 50% amount has been deposited.
Court, I will not do that. If you
But-
have a.
But minimum time, my lord, minimum time to go for before the appropriate authority, either court or.
So you have minimum time. It was, you have already lost it. When did you file your appeal? Where was the final order of assessment passed?
My lord, final order, my lord, I have.
Yes, Mr. Nayak.
14/7, lordship. But yes, it is passed on 3/7/26, and they have received also. But
Yes. You have filed your writ petition after that. You have not
Up-
annexed the.
and more
provision
importantly,
final
my
order.
lord, one factual
My
aspect.
lord, I have not supplied the final assessment, my lord.
I have been instructed, my lord, to just bring a small fact before lordship. This is the Minaka area. Our officers are always scared to enter into it, number one. And every house, my lord, theft is going on by hooking. And my lord, they are maintaining their my lord,
Why have you suppressed the final order of
unauthorized
assessment?
weapons.
No, my lord, I am not, then I am not received the final assessment.
He says that it was.
But as the petitioners,
served, Mr. Nayak.
petitioner, as the
My lord, that
petitioner served to
Details,
me,
the particulars I don't have, but on third, my instruction says, my lord, on 3/7/26, they have received.
You have received on 3rd of July.
but petitioner not supplied me because petitioner may be not received by another person. Petitioner.
Maybe you challenge it if you have, but you don't have time now. But you have approached within 17. Mr. He has approached during the.
Yes.
You can approach the appellate authority.
Yes.
My lord, minimum time, my lord, I'm paying minimum time to, because I am arranged to the 50% amount.
That I will not grant any coercive action and all. I will not say that. I can grant you time to prefer appeal. You prefer appeal in accordance with law.
And furthermore, my lord, though it is
And since you have
disconnected,
filed the writ petition during the.
now they are going on with this, my lord, hooking again. Our persons, my lord, scared to enter into the area.
Go and take the help of the police and do it.
Police is all, my lord, what I am not
প্রত্যেকটা
here
মামলা-
discussing all this because not in writing. But today also in the morning, they are saying that we are scared. What shall we do? In the village, we cannot enter into it. In every house, this thing is happening.
I have that there is also that 100 houses, all that rate that they are hooking. Is this
They must be
possible?
Yes, it is possible. Why not?
Everybody, my lord, that's my lord
Nothing
specific
is
allegation.
impossible.
Whole area is conducted by hooking.
Yes, maybe. In some cases, it is possible.
আপনি আছেন 3 তে? My lord, item number 3, I am also appearing. Well, in this case, my lord, petitioner last paid electricity bill, but in despite of electricity bill and that,
That you are challenging final order of assessment.
yes, final
Attended,
order.
attended hearing, received the copy, 1,87,566.
But I have paying electricity bill regularly,
Neither
kind.
here nor there. Electricity bill is for current consumption charges.
Yes.
If you commit pilferage of electricity, you will be charged for it.
They are falsely alleged that I am
Why
there.
don't you prefer
There is-
appeal? Whether it is true or false, how will the writ court decide this? I am not an expert. This is to be done. That is why the appellate authority has been
actually,
formed, because they are
technicality-
engineers. They will find out whether there was real pilferage or there is something wrong. Why are you coming here in writ every time? The writ courts, there are several judgments now that we cannot intervene. If you could show that there is a jurisdictional issue involved,
Yes,
the
my lord.
authority did not have jurisdiction, like one of the other cases
Yes,
which you
yes,
cited,
yes.
I entertained. This I will not entertain. There is no jurisdictional bar on merits. What will I do? I don't know anything about it. I don't know whether how it is calculated, what is
Yes,
wrong
that
with
is
the meter.
that is
I have
technical
no idea
engineer.
about it. Yes, the persons who are experts in the field. That is why the
Yes.
legislature has appointed the appellate authority. Why are you coming here? And you have also lost your time to prefer appeal.
Well, the same order may be passed, my
So,
lord.
my lord, same order may not apply because 23rd June, they
Okay,
received.
so 23rd June.
I
to
have annexed the
23rd of
final
July.
assessment.
He has approached on 17 July, so it was within time.
No, 23rd of June, they received the order.
Yes, so 23rd June to 23rd July, 30 days they will have. He has approached writ court on 17th within the time.
Very well, lords. Double benefit, lords.
This writ petition assails an order of a final assessment, order of final assessment. Final order.
এইটা 4 হচ্ছে।
Same thing.
No,
But,
my lord, in this only the jurisdiction, there is the fit case for jurisdiction. Because
Kindly see
petition-
once, my lord.
Petitioner's house is situated at the district of South 24 Parganas under Jibontola's customer care of
This is the
Duto.
next page, but the last paragraph. The petitioner's representation, where he admits
That is the forcefully, that is. Under due
But
is the
what about this point he is raising? Because in other matter also he raised that his electricity, the station manager who has jurisdiction over his electrical appliance.
Yes,
is of
my lord.
Jibanpala, and this station manager is Minaka.
that is his submission. Now, my lord, my instruction, that point was taken, but it has been ascertained that it is within that jurisdiction. However, he ought to have preferred an appeal straightway.
If it is
My
a
lord.
jurisdictional error, then writ court can intervene because of the
Absolutely.
exceptions.
Let him,
So you prima facie satisfy that you have jurisdiction.
absolutely.
How, you tell me? You have-
But if your lordship see his objection, although this point was not taken, but my lord, the area, but because we have lodged the complaint, if it is not within our jurisdiction, police authority ought to have not taken the complaint. FIR has been lodged. Kindly consider, but he may say that this area is not within the jurisdiction of the CCC, which the Minaka CCC. But the specific instruction is that it is within the. But suppose today,
How?
if this is not our jurisdiction, why this station manager will go? He has not. But he
No, that is what he's submitting, that they should not have gone. How do you say that Mina Khan does not have jurisdiction?
My lord, kindly see the final assessment address of the petitioner's house.
So what?
My lord, kindly that
You see page,
district
page 14 first. This is your bill. You are relying on this bill.
my lord, it is another bill. My lord, it is the petitioner's house, that is the Minaka under Minaka police station.
Oh, you are relying on this bill or not? Why
No,
are
no,
you
no.
showing
That is another house petitioners that is situated in the Minaka under Minaka, that is consuming electricity by Minaka CCC.
Where is the
But-
where is the bill in respect of this house, which is not under Minaka? Show me that.
There is no bill, my lord. That
he
is- that
appeared-
is the jury.
he filed written objection. He appeared.
My lord, that
The
is
bill shows that it
there
Minaka,
is
you have different houses in
petitioners
the-
another house that is situated in the, there is no electricity. Kindly see.
There is no electricity and still they are raising bills and you are
No,
paying.
no, my lord, bill is another house that is situated in Minaka. Minaka, and one is the road. In the roadside is Minaka, and another side is the Jibontala CCC. That is the problem, my lord. Actually, petitioners has not Pakka construction. That
And
is,
let him
that is-
let him show the written objection, my lord. According to him, he has not received my specific instruction. I have handed over to your lordship.
that
He
is
received the provisional bill.
curious, that is
He filed written objection. Written objection can't be forceful. Written objection, he filed suo motu. Now, my lord, kindly see, I have produced you before your lordship, my lord, the written objection.
But without written objection, that they did not the final
Absolutely
assessment.
not. Absolutely not. Let him say by on oath that it was forceful. And they were compelled to write this.
You have jurisdiction over both Jibontala and Minakhali.
But the
No,
area,
Jibontala, another Jibon.
Please wait.
the area, my lord, if your lordship see, the area which, my lord, the premises was we found that there was a theft of electrical energy is within the Minaka CEC.
Because his address that you have written in the provisional order of assessment,
But this is in our jurisdiction.
PS Jibontala is in your jurisdiction.
But this area, particular area where the meter room and where the direct hooking was there is within our jurisdiction.
And where have you lost the FIR?
My FIR, my lord,
FI Jibontala police station. South Chobbish Pargana.
yes, my lord, kindly see, this is the provisional assessment.
Provisional assessment he has annexed, page 15.
Yes, district South 24 Parganas. Minaka is under
Minaka and
24.
Jibontala both are South Chobbish Pargana.
No, Minaka not 24 Parganas.
My specific case is
Mr. Mukherjee, please take specific instructions on this, because in other matter also I have adjourned it.
very
Please take instructions, because this needs to be sorted out. It's a jurisdictional issue. Please address it properly so that it is done once for
absolutely,
all.
absolutely. Kindly keep it on, my lord. I will take specific instruction, my lord, next Monday.
You can-
Another district, my lord, a Murshidabad district.
5 who is appearing? Yes.
District Murshidabad.
Yes.
My lord, same,
this
my
is
lord,
ultimate-
I am paying electricity bill, but
এটা পে
forcefully that they assess, you know,
When did you get the order of provision? Final assessment order, when did you get, Mr. Mukherjee and Mr. Naik?
The Lordship, on 4/8/26,
4/8.
4th of
August.
August, my lord,
after filing of the writ petition.
1,89,966. And my lord, this is the second time
Done
theft. In 21, he grateful, Lordship.
My lord, I am for the petitioner. I am being led by, my lord, I am being led by learned advocate Shumon Basu. He is appearing virtually, my lord.
Yes, what is the matter? Where is he? What is he doing?
My lord, maybe a network issue, my lord.
What is the matter? You tell me.
My lord, in the year 2013, the petitioner applied for electricity transformer for his personal use, and he was approved the use of electricity transformer use. He purchased it at his own cost and installed it. Then, my lord, the petitioner came to know that the private respondent was illegally using the electricity transformer, and he made a representation to the state electricity distribution company regarding the same. And my lord, that representation was received by the distribution
The
company, but wasn't
transformer
considered.
is privately in your name?
Yes, my lord.
Usually not. Transformer is always the property of the WBSCDCL or the electricity licensee, whoever it is. Transformer may have been installed for the purpose initially to cater to the load requirements, but that does not mean that it becomes your property.
My lord, this,
My instruction is that company has my lord given the connection.
Has to be. Transformer cannot be anybody's personal property. It cannot
my
be
lord, the
dedicated.
transformer, I deposited the money.
Maybe.
I may, my lord, kindly. My lord, I deposited the money. I paid the whole amount of the security deposit. A quotation was raised by the department. According to the department, I installed the transformer. My lord, thereafter, the private respondent given connection by the electricity department.
Transformer cannot be dedicated to you. It cannot be a person's individual property. If that
My
is the
lord,
case, then in that case, nobody will be able to get electricity.
Yes, my lord, but the thing, but.
No, item number 6, my lord, I am appealing to the petitioner, my lord. In this matter, my lord,
Clause 13, regulation 53, I don't have, my lord. Clause 13, regulation 53, my lord, makes it clear. We can cater, my lord, yes.
Never,
My lord, kindly consider my representation.
my lord, in
use.
There is no use of considering, my lord.
No use. A transformer is always for the purpose of public benefit. It can't be somebody's personal property. Yes, if it has been installed at your land, you will be entitled to some rent. You will be getting rental compensation. Regulation?
Regulation 53, clause 13.
Yes. Ownership of assets.
But because of the new connection, my lord, my voltage is.
Go through this. Eta din onake.
My lord, kindly come to page 20.
Not required. That is the law.
My lord, kindly see what the problem is facing by the petitioner nowadays, my lord. It has been dealt.
What is the problem?
My lord, the voltage is dropping, my lord.
That they will have to address.
My lord, kindly consider that portion, my lord. My lord, only that much.
Then my lord, he has to make fresh representation for that one, but his representation.
That is not your concern. You are for the private.
My lord, my voltage is dropping, my lord.
WBSCDCL authority will see whether
My voltage is dropping, my lord.
voltage problem is there, whether there is.
There may have some other difficulties, there may have other technical
Please see
problems.
to that. So far as
Yes.
ownership of transformer is
Yes.
concerned, I will say that it is not your part.
Yes, my
But
lord.
so far as the consideration of his complaint as regards voltage is concerned, why should you not see that?
In that event, my lord, there will be no requirement for any personal hearing, my lord. We shall look into it and communicate.
Of course,
Yes, ma'am.
personal hearing is not required. That is a technical aspect, but conduct an inspection, find out
Yes,
what
yes.
is the problem. Maybe because of some
Yes,
fault
some
there
technical,
in,
other
at
technical.
your end, something is
Yes,
happening.
there may have.
Likhen. The petitioner complains of
My lord, affidavit of service.
arbitrary action on the part of the respondent WBSCDCL authorities in effecting electricity supply to the private respondent through the transformer, which was initially installed upon the petitioner's request for electricity supply in favor of the petitioner. Full stop. Paragraph. It is the petitioner's case that the petitioner applied for electricity connection in the year 2013, whereupon, a transformer was installed upon payment of costs and installation charges by the petitioner in favor of the respondent WBSCDCL authorities. Full stop. The petitioner asserts that since the transformer was installed for the purpose of effecting electricity supply in favor of the petitioner, therefore, the transformer cannot be used for effecting electricity supply to any other person. Full stop. Paragraph. Learned advocate appearing for the petitioner submits that the WBSCDCL authorities are acting arbitrarily and illegally in using the transformer that has been installed for the purpose of effecting electricity supply in favor of the petitioner to supply electricity to the private respondent. Full stop. Paragraph. Mr. Chattopadhyay, learned advocate appearing for the respondent WBSCDCL authorities submits that transformer was installed for the purpose of catering to the need of the people in the locality, and the petitioner was one of them. Indeed, the petitioner was the first to get the benefit of the transformer, and as such, he had to bear the costs for installation. However, that does not mean that the property in the transformer gets the becomes the property of the petitioner. Full stop. Paragraph. In such regard, he relies on regulation 13 of the West Bengal
Clause 13, my lord, regulation 53.
regulation 13. That is notification 53. Regulation, all these are clusters of regulation. Regulation 13 of West Bengal Electricity Regulatory Commission within bracket recovery of expenditure for providing new connections bracket closed regulations, comma 2013, full stop, paragraph. Heard learned advocate, acha. It is further submitted by the learned advocate appearing for the petitioner ওখানে উপরে ওনারটাই লিখে দেবেন that the petitioners electricity the voltage of the petitioner's electricity supply is fluctuating because of the electricity licensee using the said transformer for supplying electricity to others in addition to the petitioner. এটা ওনার সাবমিশনে রেকর্ড করবেন। এবার নিচে চলে আসুন। Heard learned advocates appearing for the respective parties and considered the material on record. Full stop. Regulation 13 of the aforesaid 2013 regulations reads as follows. বলে লিখে দিন ownership of assets colon তারপরে লিখে দিন irrespective of bearing of the costs of the extended portion of the distribution mains, comma, electrical lines, comma, electrical plants, comma, etc. dot incurred for the purpose of giving new connections to new consumers either in full or in part, comma, the assets so created shall be under the ownership of the distribution licensee, comma, who shall bear all expenditures for their maintenance and replacement. Full stop. Paragraph. Quote করে দেবেন, paragraph. A perusal of the aforesaid regulation would make it clear that the ownership of the transformer would not be with the petitioner but would remain with the distribution licensee, i.e. the WBSEDCL. Full stop. In any case, comma, it is not the petitioner's case that the petitioner has been maintaining the transformer as well from the time of its installation and has been bearing the costs of such installation. Full stop. Paragraph. Insofar as the second grievance of the petitioner is concerned, that the petitioner's electricity supply is getting fluctuated, comma, indeed, comma, the WBSEDCL authorities would
Due to
remain
overload,
obliged-
my lord, due to overload, due to
would
overload.
remain obliged to look into such grievance and to redress the same if it is found that such electricity supply is fluctuating because of some fault at the part of the on the part of the WBSEDCL authorities. Full stop. If, comma, the WBSEDCL authorities find that it is due to overloading, comma, they will take appropriate corrective steps. Full stop. Paragraph.
My lord, kindly frame a time, my lord, 4 weeks.
The WBSEDCL authorities shall conduct appropriate inspection and take appropriate measures in accordance with law for the purpose of redressal of the grievance of the petitioner, comma, if the same is found genuine and redressable by the WBSEDCL authorities within brackets, i.e. the fault is not at the consumer's installation, full stop, within a period of 6 weeks from date, full stop. With
My lord,
the
kindly
aforesaid-
make it 4 weeks because the paddy season is going on, my lord. Harvesting season is.
4 weeks from date, full stop. It is made clear that this court has not gone into the merits of the petitioner's grievances. Full stop. Paragraph. WPA 20544 of 2026 stands disposed of, no cost. Next.
Even my lord, I am for the petitioner.
My lord, I am for the WBSD.
No, only
My lord, I am for the private respondent 10, 11, 12, 14 and 15. It's a long, long
Only-
standing battle since 2012.
The only difficulty is, my lord, affidavit of service had not been affirmed, my lord, but I have served all the parties, all have been delivered. 9 is not appearing, though have been delivered, my lord, only the 13 has not been appearing. 13 has not been delivered, my lord, returned as adversely left without
You are
instruction.
not representing 13.
My lord, no, I am not representing 13. I have 10, 11, 12, 14 and 15.
No, all are the same legal heirs of, my lord,
What is your grievance?
my lord, new electricity connection.
Mr. Kole, what is your problem in effecting supply? He is the problem.
To shoot pending injunction order is there, not to change the nature, character and
Not
possession.
changing
No, no.
Yes.
My lord, this one is the fifth read petition on the self-subject matter. None of the earlier read petitions were proceeded to its logical conclusion by the petitioner, my lord. My lord, kindly come to the page 127. Order passed by this Honorable High Court, page 127, 128. In read petition number 5454 of 2018, my lord.
Yes.
My lord. ঠিক আছে।
Actually, this order is troubling. That's
No, that, my lord,
Just. What is the
My
state
lord.
of the civil suit? This
Civil suit is pending. My lord.
no, my lord,
again-
not pending. Not
Kindly,
pending.
kindly allow me to.
Wait. His petition is there. I will allow you.
My lord, my lord.
Yes. What is the status of the suit?
My lord, kindly come to page number 96. That was dismissed long ago before that prior writ petition has been disposed of, my lord. In the year of 2015, it was dismissed for non-appearance by the plaintiff, who is the private respondent in respect of the instant writ petition. Suppressing that material fact, my lord, they have taken an order. I have taken this, my lord. I have received the information from the court, my lord, upon an application made in the month of July 2026.
Yes. Yes, sir.
My lord, 97.
96, my lord.
No, my lord.
What no?
The suit is, my lord, in order, I have mentioned at page 127 and 128. It has been mentioned that suit title suit number 37 of
No,
two.
the court was not applied
My lord, actually the process. Kindly come to this.
nothing.
My lord, kindly come.
You have filed a suit. There is no order of injunction, and they will not be getting.
My
electricity
lord,
supply.
kindly
That is the
70
law.
question of title suit is 74 of 2013. Third para, my lord. 74 of 2023. On the basis of injunction passed on that title suit, this order has been passed. And my lord,
Several other judgments prior to that which have not been
My lord,
considered by this,
yes, ma'am.
including a division bench judgment. That is not the law. That if there is an order of status quo, electricity supply will not be
that
granted, is not the law.
my lord, kindly come to the page. Kindly come to the page. Page 56, my lord, page 56. That I know, my lord, but that order has not been set aside and they have not papered.
To be set aside, that order was passed on the understanding that there is a civil suit pending. It was not on the understanding that there is a status quo order. So therefore, the order was passed on the understanding that if the
My lord,
the electricity,
I agree.
licenses
I agree.
allow the court to complete, then open your mouth.
My lord, kindly
was-
come to the page 56. Page 50.
The order was passed on the understanding that if WBSCDCL authorities are directed to effect supply, the suit will become infructuous. That was the only basis of the order. Now the suit has gone. The order has.
No, my lord, that suit is pending. Suit is pending.
There is an
Title suit 70.
information slip on record saying
Suit
that
is
the suit has
pending,
gone.
my lord.
No.
On the basis of the order, my lord,
No.
kindly come to the page 56, my lord.
Not,
Page
ma'am.
56.
Page 56 is record of
poli-
right. What will I do with this?
Page 56, my lord.
Record of right. I will not do anything on this.
My lord, there were
See,
two
The
suits.
suit which was referred to is 37.
stand in the way, my lord.
37 of 2013 is the suit which was referred to by this court.
No, my lord, 74 of 2013, my lord.
No, sir. Please see, read 128. The shouting will not do. Please read 128.
My lord,
Please read 128.
page 20.
Please read 128.
Yes, that is
Come to
written.
the fourth line from top.
Yes,
Please read it loudly.
title
that
suit,
it-
in the event an order is passed in the writ
No,
petition.
that is not fourth line. In title suit, please start from there.
Oh, acha, sir. In title suit number 37 of 2013, the distribution company is a party and the private respondent has sought a decree for permanent injunction restraining the distribution company from giving supply to the petitioner. A substantive suit in which the distribution company is a party is pending and no relief is sought for. Pending, but pending means title suit
Yes, it was pending,
pending.
on that day on the understanding.
And no
that it is
relief is
pending.
sought for distribution company too. In the event an order is passed in the writ petition, the title suit number 30, there is a typographical mistake here, my lord.
That I will not
My lord,
understand.
my second
Typographical
point of argument, I am going second. Kindly come to the page 56, my lord.
Yes, page
Page
50.
56.
Yes.
Page 56. The LR record of right, LR record of right of the petitioner showing the class of land Pukur Par, that is the bank of the water body pond, my lord, where they want to take electricity in unauthorized construction, my lord. Pukur Par, in Pukur Par, land water body, my lord.
Nothing.
And
That is for the WBSCDCL authorities.
is not inclined to pass an order to effect. My lord, may I? That I get the latest position if it is
Feasible or not? Yes.
That is also my submission, my lord. Kindly
They
keep
should
the
go
writ
and
petition
conduct an
pending.
inspection, Go and conduct an inspection and come back.
Possible, my lord. Because this is a long-standing dispute, my lord. Since 2012, I have not been receiving the connection, my lord.
Lordship, I am for the petitioner, Lordship. I am praying 1 week's time. The service is not complete, Lordship.
Not this week, Lordship. Next. আচ্ছা একটা অর্ডার রেকর্ড করি খবরদার মিস্টার
Number 9, my lord, same, my lord. Item number 9 also same.
Nobody is appearing, not today, not this week, Lordship. Next. দেখি লিখে নিন none appears for the petitioner.
My lord. Service তো আগের দিন দিয়ে দিয়েছো কোথায়
Yes, sir.
my lord, I have served all the respondent and the bank remarks on the bank service is that they have refused the service. It's a private bank, Standard Chartered Bank. There is point of maintainability arose in the last day. Your losses mentioned the judgment of the Supreme Court in the A. Soba versus Muthoot Finance. The only submission in this respect is that whether a private body who is discharging a public duty can be amenable to the jurisdiction or not. In this case, Muthoot Finance case is that the case arose from a gold pledging agreement between the borrower and here, my lord, the only difficulty which I cannot say completely binding upon this honorable court because this is subsequent judgment. Only thing is that here the bank has to maintain the strict regulation of the RBI guideline master circular having the statutory force. The only submission. If that is being done in every loan agreement, our case was that we have paid everything.
No use, Mr. After Shobha.
Yes. Only thing, my lord, I will ask indulgence, pray for
I'm for the petitioner, sir. Service on the respondent could not be completed.
Not today, not this week.
Lord,
I'm for the WBSC DCL.
Lord, this is my service. Lord, very innocuous prayer, Lord, kindly see the prayer B,
There be.
my Lord. For enhancement of the voltage.
Yes, sir. Why are you not considering it? Consider
kindly-
it, say whether it is required, not required. Tell him that. Don't report that.
Yes, my lord, dispose of kindly, page number 32, representation to be disposed of within stipulated period.
That is what I'm saying.
Yes, page number 32, representation.
32, chairman.
No, it is actually addressed to chairman, but it has served upon the station manager.
Lord, page 33 is there.
Chairman is, page 33 was sent to the chairman. Chairman will not do, my lord.
33 is there. Station
33, my lord, it has been sent to chairman, my lord.
No,
No, station manager.
But see, there is no seal. It has been served upon that, page
Oh.
32 was served upon the station manager.
The station manager will take decision.
Yes.
The writ petitioner exercise will be complete.
My lord, item 14, my lord,
I am for the petitioner. My lord,
my instructions, my lord, we've not received a copy of the writ petition.
I have served all the,
Survey copy
I
on him. I'll make it not this week, survey copy on him. Not this week. Next.
bibliography.
Should I record model for this? Okay.
I am for the petition in this matter. Education.
Is there for
Well,
service is complete.
Well, I have served not to the Union of India, the government pleader, the bank.
What is your
My lord, my grievance is that my lord, I am in very pathetic condition. My lord, I am is neither a borrower nor a guarantor. My lord, a proceeding under section 13(2) was initiated against one Chaudhuri. My lord, I am is not the Chaudhuri. My lord, the plot which has been mentioned in 13(2) notice, 13(4) notice, and as well as my lord, the order of the my lord, district magistrate is plot number 2019. What they did, in residence, my residence at the separate plot, they took possession of the my plot. Where 2019 is a vacant land, my lord. I am in out of my residential premises. I am staying outside. They with the police help by virtue of the strength of the order of the SCGM, took possession of my residential premises. My payer is to restore my possession.
where is your affidavit of service?
My lord, I have served affidavit of service, my lord. I am in the government pleader.
Affidavit of service has to be there. How will I take cognizance of that?
May I, my lord, just
How have you served the banks?
yes, my lord, by speed post, my lord, I have served.
Yes, but where is the postal track report? Nothing is
The
there.
postal record is there.
It's only postal receipt, no track report showing service.
My lord, may I just come back, my lord, not to do, my lord.
Not today will not do. You have to show the track report also.
My lord, actually,
Service on the private on the respondent.
Lord.
You have only got the postal receipts. You
My
don't
lord.
even have the track report.
May I come back on Thursday, my lord, as the lordship?
Thursday, what will you be able to do? You will be able to show service.
My lord.
So Thursday করে দিন 27 তারিখ করে দিন Tomorrow 27 করে দিন 1st September. But you have to show service. 27.
I'm deeply obliged, my lord.
Yes, next.
I am for the petitioner, lordship. 16.
Well, I for the CSC authority.
Lordships, petitioner has applied for a domestic connection for his her residential premises, lordship, having the occupancy documents. The CSC authorities has not taken any steps, lordship.
No, my lord. My lord, we went on. Inspection was done, my lord, June 22. The inspection was done, my lord, on June 22, my lord. Fact is that, my lord, petitioner is residing in a small room in a large pasty premises, my lord. There is no toilet, no kitchen, only one room, my lord. And already she is enjoying the electricity, my lord, benefit electricity. We have already
Lordship kindly sees their communication, the same communication that we have not located the premises and she is getting connection. Lordship kindly sees. This is the
conduct inspection properly, inform him. This will not do.
Okay, my lord.
Lordship,
Correct this letter also.
Lordship kindly sees the same. This is the third time.
What I have said that he has not identified the portion of the state premises where we give the connections, my lord.
Your conclusions are contradictory. Once you say that he has not been able to identify the premises, you could have stopped at
not premises, my lord, portion.
Very well, portion. if you say that the portion is not getting electricity, is not being identifiable, how do you come to the conclusion that he is getting electricity supply?
Inspection, my lord.
Both these conclusions cannot run together. If you have found the premises and he is in using electricity supply, that is one conclusion, acceptable, good. You say I cannot identify the portion, then in the next line you say that he is enjoying electricity supply. How both can go together?
We found the premises, my lord, but could not trace the portion of the.
Even if, very well, if the premises is there, you have not been able to identify his portion. How do you come to the conclusion that he is enjoying electricity supply and therefore you are unable to accede to his request? You will be unable to accede to his request only if you can say that he is enjoying supply. 100 other persons are enjoying supply, he is not enjoying supply, he is entitled to it. Maybe the premises may have several flats. The premises is fed with electricity supply. One flat owner in one flat is not getting electricity supply. Can it be a ground for refusing him? This letter has no basis.
Inspection report, my lord.
Date and time.
Brother.
I'm for the petitioner, my lord. On the last occasion, my lord was pleased to direct us to serve.
And for the bank, your lordship.
Not a small issue is involved, my lord. The property is a scheduled tribe. The owner of the petitioner number 2 is a scheduled tribe. That land has been scheduled as a scheduled tribe property, my lord. That property has been mortgaged, my lord. They have issued 13-4. We have preferred application before the DRT, my lord.
Yes, sir. You are appearing for the bank.
Lordship.
You are appearing for the bank.
I am for the bank, your lordship.
Yes. How do you respond to his allegation? He says that the there is a jurisdictional error. The property is a scheduled tribe property.
My lord.
How will SARFAESI action be possible there?
Lordship, so far, Lordship's wisdom, your Lordship, I have upheld law which knowingly fully well entire things.
Question is whether you can exercise SARFAESI action on that or not. May have availed loan. Your mistake, you cannot take advantage of your own wrong also.
Lordship, this is not the part of the mistake, your Lordship.
It is. You should have
As
checked
because in
before taking collateral. You should have checked whether the SARFAESI action would be, feasible or not on the property in question.
Lordship.
Make arguments in law. This argument will not help.
Lordship, I am with law, your Lordship.
Yes. Show me,
I'm with your law.
some authority on this that you can proceed on a schedule.
Lordship, in Axis Bank, Lordship, judgment is not in my hand, but your Lordship in
You bring the judgment, then let us not waste time. When will you able to bring the judgment?
Lordship, 1 week time be allowed. Only 1 week time.
1 week.
And your Lordship, allow me to file opposition.
Opposition, first you clear the hurdle of jurisdiction, then.
I am with opposition, your Lordship. Liberty be granted to.
But in the meantime, my lord, there needs to be stay, my lord.
First let cross the hurdle of jurisdiction, then you file opposition.
18, Lordship, I am for the petition.
I am appealing for the licensing company.
Lordship, kindly seize the last order once, Lordship. The CSC authorities had filed one report stating that they.
Lord, I have taken instruction. Lord, my instruction is this, my lord. He is right, my lord, that person, my lord, got the connection. But, my lord, I hold a conference with the officials of the CSC, my lord, yesterday evening. My lord, what I am gathered from them, that is, my lord, it is the question of safety and security of a court personnel, my lord. My lord, several meters board are there.
Then why did
Lastly,
why did you jump the queue? You should have given him. Why did
no,
you
my
give
lord,
the other
he has
person
applied,
before
he has applied, the person who has given the meter in his favor, he has applied in the year 2024. My lord, that was the last connection which was given by the licensing company. Thereafter, no connection is there, my lord. As a result, licensing company requested the petitioner to find out a place. But, my lord, petitioner is totally, my lord, is not in a position to find out any place. And CSC authority is not in a position to find out any place. My lord, this is the question of safety and security. This is a question of, my lord, several persons are there. Local people, my lord, police personnel are there.
Safety and security was not an issue when the other person was given electricity supply.
My lord, day to day, my lord, kindly visualize the situation.
I have visualized the situation.
Day
Why
to
did
day,
you-
my lord,
why
my
did
lord,
you
kindly
jump
bear
the
in mind.
queue? Why did you jump the queue?
My
You
lord,
have jumped the queue. You have given someone else over his head. You have not given him.
my lord,
Why?
he applied in the year 2024 prior to the
Where is-
petitioner's
where
application.
is the proof that he applied in 2024 and when do you apply?
Lordship, this is my second application. We have applied earlier. Thereafter, in 2026, we have applied again.
What happened to the earlier application?
No connection was given, Lordship.
Yes, then
That is not the subject matter of this case.
why not? If he has applied once and you have not applied,
My lord, he
you
has
have to
not
apply again.
My lord, he has not, my lord, my lord, it is the pleading is not there to that effect in this writ petition. So far, my understanding is
there to show that you have.
then, my lord, kindly direct him to bring him, take record, my lord. I will take instruction, my lord. In the air, my lord, I cannot take any instruction, my lord.
Lordship, the
It is
meter
it is
room
a verbal
already have
submission,
enough
my lord.
space to install 1 meter. I am not going into the factual aspect. Lordship, kindly seize the photographs annexed to the
My
exception.
lord, kindly direct him to take the responsibility and to find out a place, my lord.
Lordship, the writ
Who you
petition.
please, my lord.
First responsibility will be on you. There was a writ petition filed. He asked for electricity supply. On his head, you went
My
and
lord,
gave
we
him
are always
something else.
ready to give connection because,
Doesn't
my lord,
appear
it
to
is
be
our
so.
earning. This is our job.
It doesn't
We
appear
are
to
here
be
to do this. But, my lord,
It
difficult.
doesn't appear to be so, sir. It doesn't appear to be so. All these tricks will not work. If he had applied for electricity supply, you kept him waiting and you gave the person who is later in.
My lord, it is verbal. It is a submission from bar, my lord. Kindly direct him to put in record, my lord. Then, my lord, I will take.
Your submission is also submission from the bar. What is on record? What have you brought today to show that he had applied before him?
Yeah, my lord, to that effect, I have no
document do
instruction,
you
my
have?
lord. To that effect, I have no instruction, my lord. Prior
What
to
document do you have in support of your argument that the person to whom you have supplied electricity had applied earlier to him?
My
What
lord,
is the document?
my lord, so far my understanding,
when
my
it
lord, I
comes
have
to you-
filed exception. Thereafter, he has
whatever it is.
I have filed the
There
exception.
was this was the specific direction on August 19, 20.
My lord, I have filed report, my lord. Then, my lord, I have to file a further report, my lord.
Why did you not bring it today? You should have brought it today. You should have brought something on record to understand that yes, this is the case.
My lord, kindly give me a direction to file another report, my lord. By that report, my lord.
Lordship, let them kindly consider the space in the meter room, Lordship. I have annexed the photographs. All the persons who have applied for the connection, Lordship, kindly seize the photographs. They have added sticker in their name in the meter room. I have also added one sticker in my name. They have given in the name of some Oyon Pramanik who applied as per their statement before us. Lordship,
After
our
filing our
petition
report,
was,
my lord, after filing our report,
and
my
their
lord, he
report
has
also did not suggest the name of the Oyon Pramanik. They have entirely suppressed that, Lordship.
Aspirate for comma leave
my learned friend was supposed to, produce a regulation. This is that school matter where,
May I just remind your lordship. Now, my lord, we issued bill. The petitioner may choose not to pay. Rather, he applied before the ombudsman. Now, my lord, ombudsman, my lord, pass an order, thereby rejecting his claim. He came up before this court. Before this honorable court, my lord, our submission was that first of all, it is an appealable order. If someone has agreed, he ought to have preferred appeal. There's a little bit mistake on my part, not ombudsman. That was by the RGRO. Now, my submission was that if he is aggrieved, he has to prefer an appeal before the ombudsman. Now, on that stand, the petitioner's learned advocate at that point of time says that his client wants to pay the amount and he only needs the installment. Now, I agreed, my lord, order has been passed by the coordinate bench directing him to pay the amount by 4 equal installments. Now, my lord, he has paid some amount. Then we said that your lordship knows, now, my lord, when the bill has been issued and when he has paid, during that period, the late payment surcharge we have to issue in terms of the regulation. Now, my lord, we issued the late payment surcharge bill. He is agreed by that, saying that the earlier coordinate bench directed for payment of the bill by 4 installments. Therefore, no question arises for payment of late payment surcharge. May I clear? Now, my lord, on that score, your lordship asked me to bring the writ petition up and the instruction that I have produced before your lordship. Again, my lord, I am showing the writ petition earlier and my instruction to your lordship because last time your lordship handed over the same to me. This was the writ petition. Now, your lordship has already entertained and your lordship directed him to pay the regular bill, restraining us not to charge the late payment surcharge. And my lord, we have not, and we asked him to clear the dues that he has paid. Now, my lord, kindly see the writ petition, whether we are entitled to claim the late payment surcharge or not. Now, kindly see the earlier round of litigation, the prayer in the writ petition, and the order of the coordinate bench. Now, kindly turn to page 53. Page 53, the order of the coordinate bench. Now the stand, your lordship will find page 54, our stand. The learned counsel for the respondent, I have a lordship body. Learned counsel for the respondent has submitted report and submits that after raising of the bill, the petitioner has approached the RGRO against the said bill, but the RGRO has dismissed the claim made by the petitioner. Thus, the petitioner ought to have approached the ombudsman challenging the order passed by the RGRO, but instead of filing an appeal, the petitioner has filed the present writ application. Thus, the writ applicant is not maintainable. He further submits that as the petitioner has not paid the electrical consumption charges till February 10, 2025, and as the electrical connection has been disconnected. He further submits that if the petitioner will pay the total electrical consumption charges, the respondent will provide the electric connection in the premises subject to payment of the reconnection charges. Heard learned counsel for the respective parties. Then the direction has been given, paragraph 8. Now, before that, I say the petitioner submits that the petitioner pay the said amount by 5 installments. Accordingly, petitioner is directed to pay the total outstanding in 4 equal installments. The petitioner shall pay the first installment along with the reconnection charges to the concerned authority by November 20, 2025. If the petitioner pay the first installment along with the reconnection charges to the concerned authority, the authority shall immediately provide the electric connection in the premises of the petitioner. Now, my lord, after that, he paid some amount, we have reconnect. Then, my lord, there are certain consumption, my lord, he has not paid because we have, my lord, charged the late payment surcharge. Now, the question came up by my learned friend that earlier time when we did not mention that the late payment surcharge will be levied. Now, my lord, late payment surcharge only applicable when the bill was issued and when he is making the payment. But I cannot prejudge that or expect that he will pay the amount on that day. Therefore, this is the period for which I have to claim the amount. Therefore, my lord, my submission is that in earlier round of litigation, that late payment surcharge is a premature because I don't know when he will make the payment. Now, regulation 48, if you lordship see, 6.17.4. এটা আমি জেরক্স করে দিচ্ছি।
তাহলে জেরক্স করে নেব, কিন্তু পাবো কোথায় না? Regulation? Regulation 48. Clause?
Page 100. 6.1. Initially, it was charged under regulation 38, but subsequently that has been now it has been newly regulation 48. My lord, this is the entire book, my lord. Of now, kindly see, my lord, the page 110. Therefore, my submission before your lordship that the earlier round of litigation, no question arises for claiming the late payment surcharge because it only arises when the bill has been issued and when he is actually making the payment. Now, pursuant to your lordship direction, we have not charged, but my lord, regulation we cannot waive this late payment surcharge. Your lordship knows we can't waive unless there is an order. But my lord, we have charged in terms of the regulation. Now I leave it to your lordship, my lord.
Yes.
But if I may be favored with this regulation, this my learned friend is always privy to, we never get to see this.
These are available online also.
Yes. But online, subject to my limitation, I have, tried to, find it out. I could not. I personally could not.
West Bengal
fine.
Electricity Regulatory Commission Terms and Conditions of Tariff Regulations 2011.
My learned friend has assured me, that they will supply, a soft copy. I can come back. I can start today.
Tell me
Can come
when.
back. Any day, after this 26th vacation, any day. This is a derogable, provision can be waived. They have waived this, by their conduct and by their submissions in the earlier round of litigation, that I
There
will
was subject to question. There was no submission to that extent. We
I
can.
have not interrupted.
I'm sorry.
Very well. Then we can have it next Monday.
Next Monday, 31st, my lord.
Will be a problem. First.
May the interim order continue till that day. It's expiring today.
They will not disconnect in the meantime if you are going to pay.
But once it happens, so we are little happiness.
Mr. Mukherjee, learned advocate, appearing for the
I'm appealing for the petitioner, my lord, pursuant to your lordship's last day's direction. I've served a fresh notice upon the private respondents. May I file my affidavit of service, my lord? They have received it. My lord, the case is, my lord, that the neighbors, my lord, they were creating some obstruction, my lord, from taking the new connection, my lord. So state has filed a report on last occasion saying that they need police help, my lord. My lord, kindly take
Private
the.
respondent, anybody is appearing?
I have served them, my lord, fresh notice.
Received, they have received.
Yes, they have received.
We have put in a report, manner, on behalf of WPSCTC on the last occasion, manner.
You have any problem? No, you don't have any.
Manner, we went, there is to poles which has to be erected, manner, but we could not, manner. We have tried several times, we have written letters, everything is annexed with the report, manner. But until and unless, manner, we get free access and, manner, the way is not given, we cannot implement the job, manner.
Why are they objecting? The poles are being erected on someone else's land.
No, my lord. My instruction is not that, my lord. They are objecting, my lord, because there's a common road, my lord. Now they are saying that yes,
District
that
magistrate, manner,
pole cannot be made
page
to.
26 of my report, manner, these are all the objection letters, manner, which we have annexed.
There's, if my lord kindly sees the map also, there's the common reflection of that common road is there. Page number 29 of it.
I'm sending it to the DM for the DM to consider and pass an order where both of you will be heard, you as well as, because if there is an objection, they are not getting way leave, then as to whether it is a common road or not, or somebody else is being affected by that or not, that writ court will not decide. The DM is the authority under Rule 3 of the works of licenses rules. They will take this.
But my lord, as per their map, my lord, their reflection of a road is there. As
Sir,
per
that
their
is
map,
there.
page number 29,
See my report.
common road.
But we are saying that that is the road, manner, but there is a critical objection in respect of page 26, last paragraph, my lord. See, my client has never granted any permission, consent, or right of way for installation of any electric pole or electric line over his land. Such installation
Why are
would
they not appearing then?
I don't know.
I don't know, my lord. They're just creating objects, obstruction, my lord. Nothing else.
There is another objection letter that is at page 17 in Bengali, my lord.
And it's been going on for some time, my lord. Since 2024, I'm suffering, my lord. I'm without electricity even since 2006 because of all this, my lord. Fresh applied on 2024. Because if my lord
Page
kindly take
17, 19, 22, these all are
written objection. These are all written objections.
yes, all written.
written,
All written.
and if
Written objections.
And these were also forwarded to them, my lord, and subsequently we have given letters also stating that we need daily permission. We have tried, we could not. Because there was objection.
and my lord, if
My
kindly
lord, I am on behalf of the state. Well, actually, the WBSCTCL is the answering respondent. We are not. But my lord, whatever my lord.
and if page 6 of the report, my lord, just kindly peruses once, considers once, my lord. Page 6, the last paragraph, my lord. WBSCTCL is ready and willing to give connection and allow them to erect one PCC pole for withdrawal of new LTOH line, or even also prays for police help for executing. If that can be granted.
You are not able to provide your land for the purpose of erection of pole.
No, it cannot be because it is behind, my lord. If my lord kindly sees the.
In that case, if it is not your land and if it is someone else's land, then it has to go before the DM. Either you provide your land, or if it is someone else's land, it can't be done.
I am willing to provide my land if it can be done through that way also.
What was going on, my lord, from my lord, this application was made in the year, my lord, 2024. But subsequently, we have visited many times, my lord. But it is better, my lord, to resolve the dispute. If there is no alternative, we have not found for any alternative route also because it was they have not actually for 2 years, my lord, they have not done anything. From
the petitioner complains of
তারপর তো কিছু হবে। বলেন
Who is appearing for the
my lord, paragraph 4 I've stated meter was defective. In paragraph 5 my lord, the petitioner was shocked to receive by an inflated bill of rupees 3,72,298 my lord. Against that petitioner paid my lord 1,90,000 my lord. My lord, then challenging that my lord, appeal was preferred. My lord, well, kindly see the author of the appeal order of the appellate authority at page 27.
Page
27, my lord.
27.
My lord.
Yes.
Final order, my lord. My lord. Third paragraph, the petitioner shall make a provisional payment of 50% of the outstanding dues in terms of clause so and so of the regulation so and so within a month. My lord, as per the petitioner, my lord, out of 372, my lord, he has paid 190. So after deduction 190, my lord, the 50% of that balance, my lord, it would be. But again, they demanded, my lord, rupees ওই ডিমান্ডটা তো না they did not deduct that amount. তুমি এ করেছো
Outstanding.
কোটা আউটস্ট্যান্ডিং
Outstanding demand করেছে।
না 1,90,000 থেকে 3,72,000 গেলে কত হচ্ছে তারপরে ওরা আবার ডিমান্ড করলো 3 লাখ
Standing at the
my lord, outstanding was 1,82,000 and as per the my lord order of the final order of the appellate authority, my lord, 50% of that I will have to pay. Then the connection will be restored, my lord, and the new meter will be given. In place of 1,82,180, my lord, they demanded again the total amount. আরে এটা নয় তোমাদের
এই
বলেন kindly come to page 32.
Yes. Page 32.
Well, last paragraph 4. As you have not cleared 50% outstanding dues of 3,61,000. $297, my lord. Well, already demanded that I have paid 1,90,000. 1,82,000 was due at that point of time. As per the order, 50% of that I have to pay. That 91,000 or something. But again, they said no. You have to pay the total of 50% of the total. Only submersible oil is running, my lord, for cultivation.
Previously, my lord, the petitioner was my lord, caught by direct hooking. There was a my lord, provisional bill.
That was paid, that was already mitigated. That chapter
By
was
50
closed.
provisional bill. Thereafter, he appeared. Final order has been passed. Out of that final order, my lord, he paid 50%. No dispute. Thereafter, appeal, my lord, he preferred appeal. That is, my lord, different aspect. Now, my lord, on the basis of the final order, my lord, subsequently, my lord, he paid the amounts 50% with reconnect the supply. Then my lord, he was not paying the bill. There is a huge amount dues. Now my lord, he filed application before the RGRO, not before the appellate authority. Kindly turn to page 27, the order of the RGRO. But my first order of the RGRO, my first point will be, my lord, but there is a provision of appeal. If he accepted this order, then I have nothing to say. But if he says something again regarding this order,
No, he says that you are acting
contrary to the order, page 27. I will show, my lord. Now I'll kindly see the order dated page 27.
Prior to that, my lord, kindly see a document at Joseph get the para 4A, my lord, kindly see. Yeah. 1,90,000 paid out of that.
That is in respect of the theft and other, not in respect of this. Kindly besides this. Page 27. The grievance was heard on 13 March 25. Accordingly, draft order was passed on 8/9/25. It was mentioned in the order following. Accordingly, the licensee is directed to install a new TOD meter after removing the old defective meter and reconnect the service connection. No problem. The petitioner shall make a provisional payment of 50% of the outstanding dues in terms of clause 3.5 of the regulation 55 dated 7/8/2013 within 1 month. Then kindly see, the licensee is advised to cancel all the bills raised in respect of the service connection of the petitioner bearing consumer ID number such and such. Kindly mark this portion for the consumption period 4/2/24 to 17/1/25. Therefore, this is the disputed bill. What is the disputed bill? 4/2/24 to 17/1/25. And regenerate the same on estimated average monthly consumption basis to be calculated as per average consumption of previous year of same period when the meter was healthy and take care of seasonal variation of consumption without claiming LPSC. Therefore, my lord, the disputed bill period, that bill has been set aside. Now, my lord, what we are asking, my lord, kindly see, my lord, this is the last occasion, my lord, I submitted. That's why kindly see your lordship last order. My learned senior friend was not there, junior was there. He was directed to take instruction. Kindly see. Now, my lord, the disputed bill, my lord, 4/2/24 to 17/1/25. That the chart we have given. Kindly see the next page. The total amount and minus that disputed bill comes to 3 lakh something. And as per the order of the, my lord, RGRO, we are asking him to pay the 50% of that amount. The dispute is only in respect of this particular period. And that was set aside. We were directed to issue a fresh bill. We will issue. But total period is 4/2/24 to 17/1. Amount comes to 60,000. And my lord, the total bill amount minus 60,000. Rest amount he has to pay, and not the rest entire amount, 50% only. Because the order is, when he paid the 50% amount, we will issue the fresh bill. Now, what he is, my lord, depositing, kindly turn to his prayer. First of all, implementation of the final order, we are agreeing. Second, only 91,000, kindly similar page 8 of the writ petition.
91,000, 50%, my lord, 1,82,000, 50%.
Page 8. Kindly see, he wants for implementation of the 8/9/25. We are also agreeing. Kindly see the second part. Provisional payment, but 91,000, it will not come because that is in respect of different. But I will show from my reply in the which my learned senior friend has relied upon. But page 31, we have clarified.
31. Page 31.
Paragraph 1. But this is when we received the lawyer's letter that I have to pay 91,000. We said no, you have to pay total 3 lakh something amount, 50% of that amount. Kindly see paragraph 1. FIR lodged, my lord, after receiving the order.
This is their later, my lord, after receiving the demand of justice. Before filing writ petition, we send a demand of justice, my lord.
Clarified my the position. That is one aspect, that is pilferage, and this is the outstanding dues. Both are different. Both cannot be, my lord, considered together. That's why on the last occasion, your lordship directed the junior advocate on record, or my lord, the learned advocate who appeared, to take instruction regarding the payment.
At page 31.
Yes, my lord.
Second paragraph. 1,90,000 on 1/2/2024 against outstanding of 372.
But that is in respect.
This was in respect of unauthorized use of electricity.
Absolutely. But kindly, here we have clarified everything. But he is asking for implementation of that order. In the order, what has been written? But kindly see once again the order, page 27. 50%. Kindly consider the total bill. Total bill was 3 lakh something. And the RGRO directed that the disputed bill we have to issue afresh. That we are doing. Disputed bill is 4/2/24 to 17/1/25. Now in writ petition for implementation of the order of the RGRO, he cannot say that I have paid some amount in connection with the theft of electrical energy. That point he cannot agitate, subject to correction by your lordship. Before the RGRO, his submission is that this is the disputed bill. Kindly see the appeal of the RGRO.
Yes.
But that has not been annexed. But his grievance is that, the disputed portion is 4/2/24 to 17/1/25. That's why he asked for implementation of that order. We are agreeing to that. We are implementing that order.
So this 372,695 pertains to unauthorized use of electricity.
That is different. We are not, because that is separate proceeding appeal tribunal that is pending. We are not concerned with that. Now we are concerned with the disputed bill.
The period is also different.
Absolutely different. Therefore, today we cannot say anything. Me also cannot utter any word in respect of theft of electrical energy, because that is proceeding differently.
There are two different amounts. You see,
My lord, one thing, my lord.
Just clarify what I have understood, then it will be easier
No,
for
no,
you
no,
to
no,
answer. I have understood this, that first a final order of assessment was issued against your client, holding the petitioner liable for a certain sum of money. In respect of that, you carried that in appeal before the appellate authority, and you paid 1,90,000 in respect of the final order of assessment. Subsequently, you found that the meter was defective. You lodged a complaint. They went there. They might have taken certain steps, and they disconnected the line for non-payment of consumption dues. In respect of that, they raised a bill that if you pay this, then we will reconnect. Now, this second disconnection was for the purpose of non-payment. The first disconnection was for unauthorized use. The non-payment disconnection, you sought for reconnection by way of approaching the RGRO. The RGRO passes an order saying that, no, his meter was defective. The bills which you have raised on average basis, all the bills are set aside. You raise fresh bills, and of that 50% you will pay. On payment of 50% of that, the connection will be restored. Now, of the second batch of 50% you have not paid. That is what his submission is. The first payment of 1,90,000 pertains to the final order of assessment that was raised in respect of unauthorized use of electricity. The second batch relates to authorized use of electricity and non-payment of the consumption bills. So there are two dues. In respect of one, you have paid 50%. In respect of other, entirety remains unpaid.
Well, kindly, I need them to give us that copy, my lord. I will take instruction, my lord, and come day after tomorrow, my lord.
Last occasion that.
Give him a breakup.
And a copy down. My lord, kindly keep it on Monday, my lord.
Not Monday, Tuesday.
Tuesday, my lord.
52, I am for WBSCDCL. So Lordship, kindly see the last order. There was a directions for adding the Panchayat authority as a party, and they have to file the exception to
Lordship,
the.
I am for the petitioner. I am praying for not today.
You have not carried out, yeah, you have carried out. Likhen not today too, not today.
Kindly keep it up on Wednesday, subject to.
Wednesday kore din. Next. Wednesday is a holiday. Thursday.
Oh, sorry.
Thursday kore din. Next.
The 23, I appear on behalf of CS.
I am for the petition.
I am for the last occasion, my lord, I filed my report.
And Lordship, on the last occasion, Lordship directed me to serve a copy upon the private respondent I have served.
My lordship.
Lordship, the CSE authority has filed their report. They are ready and willing to give the connection upon production of certain documents. We have already annexed those documents and we will also produce before the CSE.
My lord,
Your objection.
my lord, I have a very innocuous prayer, my lord. Kindly see page number 12 once, my lord.
Well,
The estate owner, my lord, has issued a certificate by stating that, may I place, my lord? To whom it may concern, this is to certify that Sri Karan Gupta, or tenant of one separate portion of second Amarbor Saroni, Kolkata, wants to take electric connection. We have no objection if he is provided with separate electric connection from CESC, my lord. We do not have any objection if a separate electricity connection is provided to them, because, my lord, we do business of garments, my lord. We transfer from one place to another place. We do courier business, my lord. And I am the employee of the owner, my lord, I am the employee of the tenant, my lord, who occupy the position of the premises, my lord. Only my objection is this much, my lord, that if any fire mishappens, any incident occurs, my lord, then huge financial loss will be.
supply. Why will fire
Separate connection may be granted, my lord. We do not have any objection, my lord. Earlier also, my lord, 2 times fire.
Only the meter
The
board.
fire safety, if they are taking the responsibility, we do not have. Grateful.
I am for CSC.
New connection, inspection done.
I am preparing for the respondent. My in pursuance to the directions, earlier directions, an inspection has been carried out. May I file the inspection? It is a precarious position, Lordship, the CSC is facing. What happened, Lordship? We are ready and willing to give the connection, but there is an existing premises where the tenants are there. Yes, it is true, he is not there. There may be a owner who is not staying there, but there is a tenant, and on that basis, the meter board has already been constructed. We have made an inspections, photographs are also given, and we are ready and willing to grant the connection subject to police help. But this is the situation, but we are getting stiff resistance from the private respondent.
Yes, you have found them to be in possession.
But at that juncture, we found that tenants of the petitioners are in possessions. Petitioners were not in possessions. The petitioner.
It is true, my lord. Here is the deed. Number 2, my lord. My lord, it is true that tenants are living under my direction. That is my lord.
Maybe. As an owner also, he is entitled.
Yes. Yes. Because I may be owner of 10 houses.
Lord, may I? Lord, after going through the report, my lord, after going through the report, my lord,
My turn.
as it has been inspected by the.
What is your right to object?
Yes, Lord.
What is your right to object?
Lord, my right to object is that, my lord, if your lordship kindly, what was the pleading in the writ petition?
Whatever it is, what is your right
Yes,
to
Lord.
object?
I am. Your lordship kindly take.
He has produced prima facie evidence to show that he is owner.
Yes.
Now, are you disputing his ownership? Do you have any decree by which this has been set aside? This deed
No,
of conveyance?
it has been challenged. Lord, may I? If your lordship kindly bear me for 1 minute, Lord. Your lordship kindly once. Paragraph number 2. Lord, it is the specific pleading. He has a house there over that land. It is their specific pleading.
So what?
But if your lordship kindly now take pain to come to this, my lord, he has never pleaded there are tenants. Now it has come from the report.
Not required. Not required. I may have a house which is tenanted. I may have a house which is tenanted. Does that disentitle me to have electricity supply?
Now
you answer the question first. Don't
Yes,
go
sir.
on arguing. I have a house which is tenanted. Does that disentitle me to have electricity supply in my own name?
No.
Please go through section 43.
No, my lord, I am.
Please read it. Please read it. Who is entitled? Either an owner or an occupier.
No, I am not denying. I am not
satisfy the definition of an.
I am not denying that, Lord. I am not denying.
That's
May I,
the
may,
end of it.
may I indicate only one more thing, Lord? If your lordship kindly allows me, Lord.
Indicate something which is sensible.
No, yes, yes. I am trying to, Lord. I am trying to make out a case, Lord. If your lordship kindly allows me, Lord. Lord, what I am on, Lord. Lord, as per his petition, as per his pleading in the writ petition, he has stated that he has a house, but he never pleaded that he has a tenant. Now, my lord,
I have just now rejected this argument of yours. Please don't
No,
repeat it.
and second thing is that, my lord, has he produced any document that there his tenant is there? Any scrap of paper? Any
His owner,
document?
that is sufficient.
No.
His owner, that is sufficient. Ashun.
Not,
These are all baseless.
and moreover, my lord, the
petitioner
premises which is
complaints
looking
of
for, is there any
inaction
document to the
on the
record?
part of the respondents?
Is there any document he has shown to the record that
May I please, your lordship, I am for the petitioner. So it is that matter, your lordship, I have purchased a flat, your lordship.
Yes.
Well, on the last location, KMC has filed a report, manner. When it is a dispute in respect of the unauthorized construction, when I am for the CSC. When there are series of writ petition which is pending before your lordship, this is one of them. Wherein manner direction and
On that second floor plus first floor.
Yes, your lordship, yeah.
when the KMC.
Where are the others coming?
When I am
That
not
are
being briefed on
that are listed, your lordship. Other matters are also listed, appearing in the list.
All are there in the list today?
Yes, your lordship.
Yes, what is your
My lord,
report?
I have already submitted my report prepared by the KMC officials. G+2 buildings are there, that is legal. Probably the other matters, my lord, that is not legal, probably.
No, they
And my lord, by order of the honorable, this honorable court, we are actually going for demolition because there is a contempt application which will be taken very shortly. That is the whole thing.
Your supply is on the second floor.
Second floor, your lordship.
Second floor is within sanction.
Yes, yes, your lordship.
Only one thing, manner, since the second floor is the sanction portion, we will like to have a inspection.
Inspection you should have. That I also, because
before,
third and fourth have been demolished.
That are
And what
during
impact it will
demolition,
have
we
on
have to
the second?
disconnect also.
What impact it will have on the second floor? Whether electricity supply is safe there at this moment, that needs to be assessed.
And during demolition also, we have to disconnect the supply for demolition, then again we have to reconnect.
That is for temporary, for demolition.
We have to see the.
Whether he is entitled to that or not, please see, because he is not at fault. He is in a sanctioned plan.
And I appreciate, in the report, it has been stated that it has been demolished.
No, but no. In the report, it has not been stated. It has been stated petitioner's flat is in the second floor, which is within the sanctioned height. What has been demolished is the third and fourth floor partially.
Yes, that has been done. Yes.
So his is in second floor.
After demolition, Manal will give us.
My lord, this is another report. This is not my report. But তুমি আলাদা report পড়ছো।
এটা তো এক্সিকিউটিভ ইঞ্জিনিয়ার বিল্ডিং
আরে 1760
এটাই তো আমরা পেয়েছি স্যার ওই দেখো
Yes, 11th August 2026.
এই কোথায় লেখা আছে তোমার যে ভাঙেছে?
এই একবার বলেছো না has demolished the RC. Only thing let them demolish subsequent to after demolition we should get a chance to inspect, and if
go and inspect, they have done this. What more? You go
we
and
will
inspect.
We will inspect. Give us a week or 10 days, we will inspect and we will file a report before your lordship.
Yes, of course. You go, only then you will be able to assess what is
as your lordship.
Lordship, kindly sees the last order.
হয়ে গেছিল আমার কেন আসছে
ওনারা টাইম নিয়েছিলেন
I appear on behalf of the CSC.
Yes, sir. What is your right to have meter there?
I have no right to that effect, my lord.
Yes. So
but I have to shift.
You get it shifted. You get it shifted.
Two things, my lord, are troubling me, my lord.
Yes, what?
My lord, I am in penury.
That is very difficult.
I am coming, my lord. My lord, now the CSC one point of time demanded, my lord, 2,52,776. Now they escalated it up to, my lord, 3,98,000.
With time, it will go up.
Yes.
If you delay again for 1 year, it will go to 4
Delay
lakh.
has that. The time was up to, my lord, 28th August 2026. On 28th August, they issued a fresh, my lord, demand notice.
Set up with CSC. I cannot do anything
My
in
lord,
that.
only one thing, my lord. This is troubling me, my lord. The land belongs to, my lord, the person who is trying to, my lord, shift me. But he is my maternal uncle. But I am not of that. I am not of that. I may, my lord, approach before your lordship for send it for mediation, but I am not on that. But
when if you approach, I will send him for mediation, and in the meantime, direct meter to
and my lord, secondly, my lord, if my lord, my maternal uncle will not be, my lord, in heavenly peace that I am in dark or I am in, my lord, without connection.
That is
My lord,
why
my
I
lord,
told
my
you,
lord,
why
what I
don't
am
you
on,
sit
my
with
lord,
him?
the entire
Mr. Council, why don't you sit with him and sort it out?
But I tried. But I once again beseech your lordship, since my lord Justice Kapoor directed to that effect, but there is no, my lord, rigor. That's why, my lord, there must be. I approached to them, my lord, they told me that I have no sufficient time. And Mr. My
Lordship, in
learned
the
friend was
meantime, the situation is worsening day by day because in this monsoon, the entire area is waterlogged and the wiring is running just above the water, Lordship. My entire house is at stake, Lordship.
I'll give you one more day. Tomorrow, come and say if you have sorted it out.
one
Otherwise, I'll have to
subject to
pass on.
lordship sanction. But your lordship kindly visualize the issue.
What visualize? What will I do? He is not agreeable. I cannot force him.
My lord, so far as the danger may occur,
Yes.
that can only be, my lord, considered by the CSC authority.
No,
So
Lordship, PSC authority will only affect the safety of the meter, Lordship.
If it is
At
waterlogged,
your cost, at his cost, I will not give you peace.
no, my,
Not how will I work?
my lord, to that effect, my lord, if it is a waterlogged area and there is
Give you one more day, think of it. If it can be solved, it can be solved.
but
Otherwise,
one
tomorrow I
more
will.
chance, if your lordship kindly, but one more chance.
What chance? What will I do?
To talk with them. But
Talk. I have given you time.
But 1 week time, my lord, your lordship kindly see. And my lord, I am requesting my learned friend to, my lord, give some time for sitting, my lord. But 1 week time. 1 week time, my lord.
Lordship, my client is ready to talk.
Yes.
If in
But 1
Shall I
week.
send it to mediation then?
no, Lordship,
Yes, mediation will be by a trained mediator. Maybe something might click.
My lord.
একটা সুবিধা এমনি করবো আমরা
Wait,
wait আমার বাচ্চাটা যা যা বলার ওনার বাড়িতে তো লাইন আছে লাইনের সাথে কোনো সম্পর্ক নেই এখানে ওনার বাড়িতে লাইন আছে সিএসসি জানে না না আমি লাইনটা খারাপ
he is stating that, Lordship, the private respondent's premises already has connection. He is not in dark. This connection is going somewhere else.
Very well, then I'm fixing it next week. See if you can sort it out.
Lordship.
If you are not agreeable to mediation, I cannot force.
Lordship.
Not be able to.
Lordship, third, I have something on second, Lordship. Third, I have something.
Second September.
Mala 27 your lordship mala directed to mala file the delivery report. Mala it is with him. Mala we served him. He denied that we served him the quotation. This is the case. Mala
27 I'm not taking now.
okay.
Not to do.
Not today. Original side is on original side.
Your Lordship, I appear for the petitioner in this matter. The matter was mentioned on Friday.
Yes, I said you
Yes,
bring
for
a letter.
withdrawal. I have the letter from the client for withdrawal.
Taken.
My lord, in this matter, the letters of administration was granted on the last week, my lord.
No, but there is a problem here.
Yes.
Which is why I did not sign the order. देखिए এটা you have seen the will.
Yes.
In the will, you are also an executor, one of the executors.
No.
Yes.
I am not the executor, my lord.
You are.
My father was the executor.
Abhishek Kumar Daga.
Yes. My lord, what the fact is I am telling, my lord.
Abhishek Kumar, you are Abhishek Kumar.
Yes,
Daga.
my lord, Abhishek Kumar Daga.
Yes. Now Abhishek Kumar Daga is also one of the executors.
No.
Kindly see, this is what was supposed to be drawn. To which the court's attention should have been drawn. Kindly take page 11.
Yes.
Page 11. Kindly see the first paragraph after V. I hereby appoint, and thereafter, in his absence or inability, Abhishek Kumar Daga to be the sole executor. So if you are the executor, how could you appoint for ask for letters of administration?
Yes, I am saying. My father was the executor. He made an application. When he made an application, my executor right has been gone. The right of executor has been exercised. What is the point, is my lord? In his absence or inability.
Executor will be exercised only if a probate is granted. Merely because he has filed the application and he has died in the meantime, you cannot be appointed as an executor.
No.
Is that the law?
That is the law, my lord. Kindly see.
Show me that.
Yes. Kindly take, my lord. What is my copy? My lord, have Indian successor. Yes.
I have it.
Yes. Where is my copy? It's not giving. It is what? Indian successor. My lord, kindly take 232 of the grant of administration.
232.
Yes.
Yes.
Then kindly come subsection C. The executor dies after, no, before that. the deceased has appointed an executor who is legally incapable. Sorry, the deceased has appointed as an executor who is legally incapable or refused to act, or who dies before the testator or before he prove his will. So he made an application.
So he has proved the will.
He failed to prove will. He died before he failed to will.
So how is this helping you?
When the executor,
How is this helping you, Mr. Pahari?
then I cannot be. Then what? I cannot be an executor.
Because law is that you have been appointed as an executor in the will in the absence of the person who could have been the executor. He is not there. Probate has not been granted. Therefore,
but he applied, my lord. Kindly consider he applied for the grant of probate.
Complete the sentence. You are too eager. I understand. Little understanding that I have. Let me convey it to you so that you can appropriately deal with it. If the will has appointed two executors, one would be capable of doing in the absence of the other. The first one applied. Before probate could be granted, the first one died. That does not mean that merely because the first one has applied, the second one has lost authority to apply for execution for all times to come, for applying for probate for all times to come, and the second one will be entitled to apply for letters of administration. It can't be. Your right as an executor under the will still remains. And till such time that you are an executor under the will, you cannot apply for letters of administration. That is settled.
But my GA1 has been admitted, my lord.
So what?
My GA1 for the letters of administration.
So that doesn't mean that once it has been admitted, we have to, if something has been committed, a mistake has been committed, that has to be perpetrated is not the law.
My lord, my application was under section 233.
Whatever.
Kindly see 233. I am neither beneficiary.
Mr. Pahari, you have to choose. Either I hold this to be not maintainable, or you want to amend it, take any steps, you take whatever steps you can. You want to come back, you can come back. But prima facie, I am satisfied that this application for grant of letters of administration would not be maintainable since you are a named executor in the will. Letters of administration can be granted only to a person who is not an executor in the will.
Yes.
You are an executor in the will.
But if I'm a joint executor or I'm an alternative because of death, my submission is this. My lord, kindly give the 2 weeks time while, my lord, let me understand then. Adjourn for 2 weeks, my lord, I will.
On August.
My lord, the executrix wants to withdraw the probate application, my lord. This is the letter, my lord. My lord, may I pray one thing, my lord? Since I have paid, my lord, the maximum ad valorem duty of rupees 50,000, my lord, may I get back the ad valorem duty? And my lord, the original will, my lord. My lord, and my lord, kindly give liberty to file afresh, my lord, if she desires to file afresh. My lord. my lord, since my lord her family, my lord, there are some chaos, family chaos in her family, my lord. That is why, my lord, my lord, kindly, my lord, my lord, my lord.
Beg to appear for the propounder in this matter. Lord, a direction, Lord, for exchange of the discovery inspection, Lord, that has to be carried out, and judges' brief of documents have to be prepared. Lord, that direction has to be passed. And, my Lord, we have prepared a suggested issue. If your Lordship kindly takes it on record, my Lord, and your
After
Lordship
completion of the discovery inspection, my lord, take it.
takes the suggested issue on record.
Yes, yes. Not, I am not ready today.
একটু জজ সাহেবকে দেবেন না
Let me see. Exchange of this. Yes, my lord.
That, my Lord, kindly passes an order, my Lord, else the time frame won't be there. No, order will be that, my Lord, kindly just passes.
My lord, I am appearing for the petitioner. GA1 is my application seeking restoration of PLA application, my lord. My lord, the order of dismissal is at page 15. Lord, there is a delay of 139 days, my lord. My lord, para 40, page 10 of the application, my lord.
My lord, this is GA2 is my application for issue of a citation. My lord may remember I had moved an application for grant of probate where there was a minor son involved. And it had fell from my lord that a citation need to be issued to the my lord.
My lord, I'm the petitioner, my lord. It is my GA application for amendment of the affidavit of assets, my lord. I had submitted on the last occasion, my lord. My lord had satisfied himself with the merits. My lord, certain amendments are required to be carried out in the affidavit of assets. My lord, they are indicated in the application. My lord. Annexure B, my lord. B. Page 2. Paragraph 3, my lord. My lord, first in paragraph 3, the gross value of the property has to be corrected, my lord. Yes, yes, my lord, precisely. The area, the change is indicated on the next page, my lord. My lord, turns overleaf. My lord, it was I had indicated on the last occasion also, my lord, there was an oversight. It subsequently, we came to understand that there was a. My lord, this is the plan that was plan appending to this to the property. My lord, I believe there is the plan is not appended to this application, my lord. No, my lord. There is a. My lord, there was the entire floor plan of this property, my lord. We carried out, we revisited that plan, my lord. The plan is not. My lord, I'm just going through the application. Yes, my lord. Yes, my lord. My lord, may I come up with a supplementary indicating the ground plan? Yes, my lord. Yes, sorry, my lord.
You want to amend your schedule of assets in
Yes,
that.
yes, my lord.
Is the reason, then it makes.
My lord, it will be fit.
transparent.
Yes, it will be fit if we come up with a supplementary affidavit.
As prayed for by the learned advocate appearing for the petitioner.
Malad, this is an amendment application, Malad. What has happened, Malad? At the time of execution of the will, the testatrix used to stay with her own flat, and that address has been incorporated in all the cost titles. And thereafter, she lost her husband and become ill, and at the time of taking breath, last breath, she used to live with her siblings. The brothers are there. So that address has been incorporated in death certificate. That address has not been incorporated for inadvertent mistake, my lord. That address should be incorporated. This is the first pair. And secondly, what is the subject matter? The flat is the subject matter of the will. Since the flat was purchased by the testatrix and her husband, and they left with no issues, and the second class heirs of the husband is known to the no whereabouts is known to the executors. They are joint executors. Two executors are there. No legal heirs, and that is why the citation, general citation is required to be published, my lord.
The amendment has to go, then general citation.
Amendment, my lord, your lordship kindly come to the will. It is at running page number 17. 17.
70.
17. This is the Goduli apartment, 32 by 7 by 1A, Burosiptola Main Road, Police Station, Biala, Kolkata, 38. But the death certificates, your lordship kindly come to the death certificate. It is running page number 23, my lord. 23. Running page 23. The death certificate, it is her maiden address. 7 by HSR Road, PO Kalighat, PS Taliganj, Kolkata. Where she used to live at the time of death, and that is why that address has been incorporated. But I left the address to be incorporated in all the cost titles and all the cost papers. This address to be incorporated, my lord.
You want both the addresses to be incorporated?
Both, but yes, my lord. If your lordship kindly come to any of the papers, my lord, I have written it with red ink. That should be incorporated. And the citation, next citation is required to be issued.
First amendment is completed, then citation we shall see.
Yeah.
First amended, then re-verification, thereafter citation.
No matter if your lordship kindly
At the same time, it can't be done.
Yeah, yes, this is the amendment application, my lord. This is the amendment application.
Amendment application will be once when you pray for an amendment to be done in the application.
Yes.
This prayer is only in this application. This prayer does not say that this prayer should be incorporated as a prayer in the main application. That is not your prayer.
I leave that prayer. That is.
তুমি প্রেয়ারের মধ্যে বলনি এটা ইনকর্পোরেট করার জন্য
হ্যাঁ
বলনি লিভ বি কি না দ্যাট শুড এই প্রেয়ারটা ইনকর্পোরেট করার জন্য টু দি অরিজিনাল অ্যাপ্লিকেশন ইট শুড বি ইনকর্পোরেটেড ইন দ্য মেইন
Yes,
অ্যাপ্লিকেশন
that should be the prayer. For example, just as you have
No,
said,
no, my
that
lord.
this address should be incorporated.
If your lordship kindly come to.
বলে না প্রেয়ারে করতে হবে প্রেয়ারে বলনি
হ্যাঁ বলেছি
এই প্রেয়ারটা ইনকর্পোরেট করতে হবে মেইন অ্যাপ্লিকেশনে
মেইন অ্যাপ্লিকেশন
সেই প্রেয়ারটা এখানে কোথায়
We have shown in red ink what is to be amended. Where is the insertion of the prayer in red ink?
Actually, it is done with the help of the department, my lord. The department has guided in this manner, my lord. That is why I have written in a red ink in every lipi.
এখানেই করে দাও
My lord, my leave be granted to incorporate it here, my lord.
to add the prayer এই প্রেয়ারটাই
To incorporate as the prayer of the main petition, man.
মানে এই পিটিশনে ওই প্রেয়ারটা
ওই তো এই যে প্রেয়ারটা অ্যাড আছে তো
Arindam Mukherjee says that the GA not required, my lord. Leave granted for correction of prayer. GA not required, my lord. I am withdrawing the GA application, my lord. Already corrected, my lord. Prayer portion.
Already corrected.
Yes, my lord.
This is that matter where the record were.
I have seen it.
Yes, my lord.
How will you bring the authenticated copy for?
But I have a Xerox copy of the will because it is an unregistered will.
Can you say that to be authenticated?
But I can prove that it was a photocopy made from the original that has been filed before this honorable court, my lord. That much I can do. Otherwise, my lord. Because the under section 237 of the succession act, it also says, my lord, that
I have seen.
Yes.
But it says for a limited time till such time the original is recovered or authenticated.
Yes, my lord. Here the original cannot be recovered.
Original, it becomes difficult.
Yes, my lord.
Now authenticated copy also there is a difficulty because it is an unregistered will.
Yes, it's
so
unregistered.
authentication in that sense is an impossibility.
Yes, my lord. I bow down to your lordship.
So
Today morning itself, the registrar insolvency called me and I went there. He has told me that the signature of the testator as well as the attesting witness have been washed away. So that's the difficulty, I understand.
the attesting witnesses are alive.
Yes, yes, yes. Even the affidavit of consent, other heirs have also filed the affidavit of
The
consent.
attesting witnesses can come and prove the will in solemn form.
If my lord so desires, then kindly.
That can be done because that will be a way of proving the will then.
Yes.
And because in this peculiar situation where the original is not traceable and the will is not registered.
Yes. Well, then in that situation, my lord kindly keeps it tomorrow because I have to take the instruction whether the attesting witness is alive or not.
Tomorrow, if we don't come to any other conclusion, we'll go for proving in solemn form.
Very good.
Yes.
Yeah, this is my application seeking for an intervention of your lordship regarding section 307 of the Indian Succession Act. My lord, there the beneficiary has already been.
That
Yes, my lord, the permission is not required. My lord, an observation be given and my lord kindly dismiss his application.
Has the estate been administered?
Yes, it has been administered. My lord, accounts
filed your,
inventory filed. Thereafter discharge. This is the discharge certificate been given by the department. This is the certificate. Kindly, my lord, only come to page 30 of my application. There is nothing else in this application more to
Page
Like
30.
Page 30. Well, how come the bank say so? Well, it is very surprising. Kindly see, when the purchaser wanted to obtain a loan to remit the balance consolidation amount to the vendor, accounts inventory filed, it has been discharged, there is no administrator in this
Then
particular
this
estate.
court does not have jurisdiction.
Yes, my lord, does not have
This
jurisdiction.
court has lost jurisdiction.
Yes, my lord.
Since
So that, but
it
they have,
it
this
becomes
is
the
my
private
cause of action at
property of
page 30.
whoever the heirs are.
Yes, they are quoting section 307 of the
Section 307, 307
307 is during the pendency
have
of the, yes,
jurisdiction.
yes,
If I have
absolutely,
lost if the estate is yet to be administered, only
absolutely.
then.
Let kindly observe this and dismiss my application. I will be happy with it. They are
have
saying
to,
that
I
in
don't
view of the above, law officer is of the opinion that the order of the honorable court permitting the said administrator of the sale of the subject property to be obtained for the sale of the property.
I don't have jurisdiction to give you permission. How will I?
Well,
Your
these how
estate has
the
been
banks are functioning.
Your estate has not been had not been
Yes,
administered.
that's why
would
I
have-
handed over the certificate. I straight away, my lord, at the first instance, handed over the certificate.
Likhun. This is an application seeking
Taking discharge of caveat, my lord. 2-3 dates are just important, and I'll leave the case to my lord. My lord, the probate application was filed on 26th of July 2024. Caveat was filed by my learned friend's client on 20th of August 2024. And today, my lord, we are in August 2026. Till date, there has been no affidavit in support of caveat.
My lord, we have served them a letter, my lord, asking to supply us with the copy of
When
the
have
probate
you-
application. My lord,
They
they have
have
never
application.
served. It has been received as the endorsement.
Hmm? Lord, this is a letter dated 20th of August 2024. I
On the
haven't.
same date, my lord, I filed the
I
caveat.
have,
Doesn't have a copy is what he says.
no, my lord, but my lord, this is in 2024. He's waiting for me to file my application seeking discharge of his caveat. Then he'll come
He
and
has
say,
also asked for the application. You please.
my lord, I have instructions that my lord, the department is to issue because there are some formalities that are required to be done.
My lord, until and unless they
Scrutiny and
serve me with
everything.
the copy, my lord, how will, if this will be my written
But my lord, that is of 2024, my lord. We are in 2026.
Anyways, they are there. I cannot just discharge them. Let them file.
very well.
এদের কি হয়েছে
এটা একটু জর্জ সাহেবকে দিন।
অ্যাপ্লিকেশন ওরা সার্চ করবে না আপনারা দেবেন অ্যাপ্লিকেশন পিএল এর কপি ও কোথা থেকে পাবে
আমরা দেবো তো ওকে প্রবেট অ্যাপ্লিকেশন সাইটেশন হয়নি নাহলে তো সত্য
why have you not filed an affidavit in support of your caveat? For that you don't need the application.
My lord, if this affidavit in support of my caveat will be treated as my written statement, my lord, I have to go through his pleadings first to deal with all.
But he has filed, my lord, just my lord, one addition to this, my lord. He is taking this plea that I have not given him papers, that he is wrong because he has filed a parallel litigation in Sialda in 2024 that got dismissed in 2024. There, my lord, we had referred this probate application.
No, my
So,
lord.
my lord, he
What
cannot take
happened
this.
is, lordship, I have a subsequent will, my lord, of
Subsequent will be your defense.
yes, my lord. I have filed a probate application which is still pending, my lord.
No, that has been returned on 20th of November 2024. That has been returned.
My
You take an exception to this application, whatever you want to say. Let us
My lord, allow me to file my affidavit in support of caveat to this.
file your affidavit in support of caveat.
But my lord,
My lord,
this,
I have
my lord,
to-
with
I have to
deepest
deal-
of
I have to
respect,
deal
is, my
with
lord,
his pleadings,
most
my lord.
lackadaisical approach that has been adopted. He was aware of that proceedings and the cause papers there.
My lord, I have asked him the copy. He has not
But
served
lord,
me the
before
copy.
the
My lord.
Sialda
This
court,
will
we
be
did
my pleading,
provide.
your lordships.
Lord, in Sialda court, my lord, we had filed a written statement where we had annexed this particular probate application in its entirety.
My lord, in Sialda,
Now, if he is right in that, what is your answer to that? You are aware of it.
my lord, with regarding to this, my lord,
You first answer his query. He says that entirety of it is.
my lord, we were aware of that this application has been filed. We have filed caveat, my lord. They have not served with the copy of.
Not required to serve because you are aware of it. You have a copy of the entirety of the application in the
Yes.
Sialda court. That is what is submitted.
Sialda court
What
got,
is
my
your
lord,
answer to
returned.
that?
I have to take instructions, my lord.
Taking it not today, come tomorrow and answer.
Yes.
Yes, lordship.
अपनी सियालदा कोर्टे रिटर्न grateful.
Yes.
Lordship, GA1 of 2025 is an application under section 283 subsection 3 of the Indian Succession Act. Lordship, in view of the changed circumstances, I would like to withdraw my application. Lordship. I'm not pressing my application.
Probate application. Yes, my lord.
I was thinking of why can't you come up with an application, a supplementary affidavit describing this and annexing with this any other document in support of your contention that the gentleman is indeed the father and not the husband?
Lordship is
Because there is no other way out. There is no provision by which we can enter into that.
no, my lord.
But there should be something in support of that. if we have it, we can move ahead, saying that yes.
My lord, we are not pressing our application at all, the GA application. We are not making a prayer that the will should be amendment.
Now, since this has come up, the application I cannot simply withdraw, I mean, ignore this, even if it is withdrawn. So it has caught my attention now. Once it has caught my attention, I need to deal with it in a manner known to law.
My lord.
Now, in order to get over this hurdle
My lord.
of my husband should be read as my father, you have to come up with some application or maybe some proof, not only an application, maybe some supplementary affidavit bringing on record a document that yes, this is the document under which you can come to the conclusion that it cannot be husband. That I think will help both of us getting over this.
My lord.
Otherwise, we cannot just leave it untouched.
My lord. As lordship directs, I shall come up with supplementary to my
Yes, but you bring a document.
yes,
that-
along with
because,
my
yes.
my lord. I shall do
How
that.
soon can you do that?
2 weeks time, my lord.
Then I shall on that day take the supplementary affidavit and direct this PLA to
I beg to approve for the
My lord, my application for discharge of their caveat. My lord, few dates are important, my lord. Citation has duly been served on them on July 2025. Thereafter, my lord,
2025.
5. Thereafter, my lord, within the stipulated time, as mentioned in the citation, they have not filed the caveat. After 69 days, they preferred an application before this honorable court for seeking condonation of delay and allow them to file the affidavit and caveat in support thereof. Thereafter, my lord, by an order dated 11th February 2026, appearing at page 17 of the application, my lord, the honorable judge has directed them to page 18 would be relevant, my lord. Second last paragraph, directed them to file caveat and affidavit in support thereof within the specified date as mentioned, 17th February and 25th of February. Since then, my lord, I am writing to them on at least 3 occasions. They kindly supply me the copy. They have not supplied so.
Cut short for it. And to cut short.
And my lord,
May I just indicate only one thing? Lord, what I find from the records on 24th of February, Lord, the affidavit in support of caveat was already affirmed. I am told, Lord, it is there with the records. I am not sure, Lord. I have not checked up the records. Affidavit in support of caveat, Lord. I am told it is with the records.
Affidavit in support of caveat nahi.
And Lord, a copy of the caveat, affidavit in support of caveat, Lord, may I hand up to my learned friend, Lord, immediately. It's there, Lord, affirmed on 24th of February 2020. I do not know why.
Filed it in the department.
Lord, file হয়েছে কবে? 16th of April, Lord, 2026, the endorsement is there.
my lord, the order that I've shown,
Endorsement of filing will be there, I don't think. That
no, only affirmation.
না অ্যাফার্মেশন তো হয়েছে
ফাইলিং এর কোনো এন্ডোর্সমেন্ট থাকে নাকি? ফাইলিং এর তো কিছু এন্ডোর্সমেন্ট দেয় না? দেয়?
এটা কোনটা দেখা
G2 নিয়ে না
কি দেখা
You don't find any endorsement of filing. I don't remember.
না not 24th of February 2026 আমার কাছে কপি আছে হ্যাঁ আমাদের কপিটা কোথায় ওটা দিয়ে দিলাম
না আমি কোনো কপি নিই
তাহলে কোথায় গেল আরেকটা কপি করি ও আমার
হ্যাঁ ফাইলিং এর আমি কোনোদিন আমিও দেখিনি, তো বড় খাতায় নোট হয়ে যায় কবে ফাইল। there is no endorsement of filing.
এর অরিজিনালটা কোথায়?
But if it is,
Department.
Where did you file it? In the department?
Perhaps.
Yes, yes. Change of
Then
name,
I'll
there was.
call for a report.
my lord,
may I serve a copy of
my
this
lord has
evidence
already
support?
called for a report on a previous occasion when my learned friend was not appearing.
Report আছে নাকি?
Judge সাহেব দেখে report চেয়ে পাঠিয়েছিলেন, but my learned friend was not there at that point of time.
হ্যাঁ, না না, কোনো রিপোর্ট চেয়ে পাঠিয়েছিল ফাইল হয়েছে কিনা দেখার জন্য। দ্যাট অ্যাড্রেসেস এভরিথিং। রিপোর্ট এসছে কিছু?
Yes. Affidavit in support of caveat filed.
Filed.
24th.
But may I just
They
hand the
deliberately copy not served. My lord, since they are here, my lord, I'll not see. My lord, kindly put them to terms. This is my only prayer.
Yeah. File the caveat what password দেখিয়ে দিন ওনাকে।
So there was a change in advocate, my lord. That's why.
Look at it. Last line.
হ্যাঁ, ঠিকই বলেছি। Filed on 24th of February. So it has been done. Although, my lord, it will be 2026. It has been written 2016.
Oh, that is understandable.
এদিনই ফাইল হয়েছে।
Yes. You have got a copy of it now.
I've got a copy, my lord. My sub the file the affidavit service, my lord. My only prayer, my lord, kindly put them to us. They are intentionally dealing. I've written to them.
Filed it on 24th. There is no.
No,
question of
they need to serve me. Unless they are serving,
That I
they are just giving it right here, right now.
But there's some misunderstanding somewhere.
But I've written to the client. I've annexed those
I am not
correspondence with the
justifying the delay,
application.
but I am not at all justifying the delay. It should have been served immediately, but for some reason or the other, it has not been done. Lord, now when it is done, let us convert it into, Lord, the testamentary suit. Lord,
My
matter will
alternate
proceed.
Should have been converted. Has it
Yes.
been converted as
Nah,
yet?
No, my lord, I had to file an application, which is
because he has filed an
in this
application otherwise for discharge of my caveat.
my lord, my alternative prayer is also there in prayer B.
So I am allowing prayer B instead of keeping this pending unnecessarily. I am
Yes,
allowing.
my lord.
No, Lord, prayer be subject to, Lord, the modification.
Why, what is that?
Prayer be subject to modification.
Subject to payment of cost. Pay something to him.
Lord, I have
My lord, otherwise this will go on.
It's not at all
forever.
You all decide till the time I dictate and I reach the portion of cost.
The difficulty is my client is not at all sound. It's not at all financial.
Then you ask him not to press for it.
I'm sure he'll not press.
No, no, well, I'm under instruction to press for it.
He'll not press it.
After 69 days of delay, they have lost caveat. I understood. Court has condoned. That has been condoned. I understand. But
The caveat has
when
also
they have
been
given an
filed.
opportunity, they should have expedited.
Within time, it has been
You
filed.
today outside.
I
Well, this
appear
is
on
my-
behalf of the caveatrix.
Well, this is my
Second
application.
attempt at discharge of the caveat without service of copy of anything upon us.
I fail to understand what my lord, my senior friend is saying. I have served the grounds and master summons.
Not the main documents, none of the documents.
Until
Last time it was attempted,
yes,
the court said that
I will
to take
satisfy.
steps, they have not taken any steps.
I will satisfy. If my lord takes up the caveat itself, it is at page 11. Unless, my lord, a person establishes his caveatable interest, the will, so long it is probated, it is personal document. It is, my lord, until probate is granted. After the probate is granted, it is become rem. Before that, my lord, nobody can ask for the will or compel me, the propounder to ask for the will. My lord kindly takes up page 11. This is the caveat. Rule টা বের কর। This is the name of the deceased in the goods of PLA number is there. And my lord, thereafter, in the matter of the name of the caveatrix is there. My lord, kindly take a note of Malavika Chakraborty, wife of Prabir Chakraborty, by faith Hindu, by occupation wife, resident of Baliganj apartments, flat number such and such, such and such. Address has been given.
Mr. Betal, I have read it. You
Yes,
need to-
address has been given. And now, my lord, in what capacity she is lodging the caveat, that has not been, my lord, the description has not been given. The department should not have accepted this, my lord, the caveat. My lord, this is the format of the caveat as per our original set rules. This is, my lord, form 12 as per rule 24. Rule 24 is the caveat. এটা ওই সেম বই তাহলে পাতাটা বলতেছে।
Yes.
My lord, form 12 is the form.
Yes.
Form, my lord, it takes up the what caveator has to be furnished. My lord, if it is same book, it is at page 681.
Yes, yes, I have it.
Yes. My lord, got the form?
Yes.
Yes, my lord. The name, address, description, and occupation in the form, my lord. My lord, got the form? Here, my lord, will not find any description. In what capacity she is?
Right. Description is there, wife of such and such.
No, no, that is name, address, and description.
Wife of such and such is not address, it is not name.
But
Wife-
description, my lord, if find the description, Malavika Chakraborty, wife of such.
Sufficient description, Mr. Betal, for the purpose of caveat, they don't have to write the relation with the testator or the testatrix, whoever it is. That is not the meaning of this expression description. Description is sufficient to identify the person. That is the purpose. Now he has given his name or she has given her name and
Even, my lord,
husband or wife of some such that I think prima facie satisfies the description.
yes.
Address is there, occupation is there.
My lord, in what capacity she is filing the caveat requiring citation, my lord, that has not been
That
has not been, because,
once you question that, she will have to explain
yes,
that.
yes, because she is neither the heir in intestacy of the deceased, nor she
Mr. Shamanto, you use an affidavit to this application.
I'll file an
Let him use an affidavit.
affidavit. Only one thing. Here, my lord, the will is on the basis of an earlier will.
Whatever it is, you seeks your discharge, you prove that you have a caveatable interest. That is the most important thing for you.
But my lord, I also need the documents. They have not
First,
given.
you cross this hurdle of you because he's challenging your authority to lodge a caveat.
But my lord, earlier, if your lordship sees the earlier order passed by this court, my lord, kindly sees that, my lord.
Yes. I have annexed. Page 8, my lord. Page 8.
19.2 at page, my lord.
8.
Page 8, my lord.
Yes. Page 8 grants him liberty to take such steps as he may be advised in law. He has taken this step to get you discharged.
Lordship will grant me 3 weeks time and I'll.
This is an application.
Because, my lord, the will cannot be given to anybody unless it is probated.
Lord, this is my application, Lord. Lord, this is my application for inventory of the locker, Lord. Lord, Destatics had a locker, Lord, in State Bank of India, Lord, Salt Lake branch. Lord, petitioner filed an LA. Lord, he has incorporated the locker number, Lord, in affidavit of assets, paragraph 6, page 6. But he has no knowledge about the inside of the locker, Lord. That is why, Lord, it has not been mentioned in the affidavit of assets, Lord, what are the assets within the locker, Lord.
You are the executor.
Lord, it is an LM, Lord. It is an LM, Lord, without will.
And who are the other heirs?
Only 2 heirs, Lord. One has filed the application, other is consented. 2 sons, Lord. One son has consented and other son has filed this LA without.
Application ta ache?
Lord, I have annexed the affidavit of assets.
Affidavit of assets won't do. I need to see the heirs. Because you want to have an inspection of the bank locker, so
Yes.
it has to be in presence of the heir, even if he has consented.
Not one heir, Lord, only Lord, thing, Lord, one brother, he is staying in Canada. Lord, he has no objection, he has given consent to that LA.
Very well, then let the application kalke rakhle peye jabo. Not today. Let
Lord.
the application come.
Lord.
I have a similar prayer like last one. On the last occasion, Lordship was kind enough to direct your Lordship's officer to bring the original probate application. This is an application by the executor for inventory of the locker of the deceased. The applicant is the I have stated, my lord, in paragraph 6, the Chinmoy Chaudhary, Lordship will kindly have come to page 3 of the probate petition, my lord. Relationship has been specified in the table. Lordship will see the Chinmoy Chaudhary. Chinmoy Chaudhary is the executor named in the will. Yes,
what about the he was unmarried?
Who? This is a will, joint will of the
Paula Chaudhary.
mother and daughter. She was spinster, and the husband PTC. Well, I have annexed the certificate also. Somir Kumar Chaudhary, the first death certificate was you will find. The last death certificate is there before this will. The husband of the
application for what? Grant of probate?
No, grant of original application for grant of probate. This is an application for Muslim.
I'm speaking about the original.
Grant of one has applied for and another brother is given consent. Vinal Gandhi Chaudhary, he has given consent. He has filed his consent. Affidavit of consent is also there.
Both mother and daughter have executed the will together.
Yes, it is joint. You have the section 15, they are the only legal heirs. Section 15 of the I have problems. বার করো দেখি এটা তো
1-5.
Yes. I am squarely falling into B. Firstly, general rule of succession in case of the Hindu female.
You are a Parsi?
No.
Section 50 is for Parsis. 50.
15. 1-5. Can I handle?
1-5 is domicile acquired by woman on marriage.
No, well, kind of law. Yes. I'm calling B. Kindly want to excuse me that pencil mark it.
And the daughter was unmarried. Daughter was unmarried. Where is that mentioned?
Thank you. In the wheel, it has been specifically mentioned. The wheel. Olokananda to? Olokananda is daughter.
So will, it is not mentioned that she was unmarried.
It is not in that way.
But that has to be brought on record, because how will the court presume husband is an first class heir? Then, because once you want to take inventory, I must be satisfied that none of the heirs have any objection. Even otherwise, that will be required for the purpose of the grant.
She will be liberty to file a supplementary affidavit disclosing that.
That is important, because the chart of heir also does not show that. You have to show that. There has to be a pleading. How soon can you come?
Doctor will only fix it on the next Monday.
As prayed for by learned advocate.
Pursuant to your
It will be
lordship's
difficult.
No,
otherwise
no, no, no.
at the time of
I
grant,
can,
it will be difficult.
I can appreciate your lordship.
pursuant to your lordship's direction dated 17th of August, my lord, I have preferred a supplementary affidavit, my lord, disclosing the death certificate of the mother, my lord.
So apart from the mother, the other heirs have consented.
Yes. Details of the heirs are at page 3 of the petition, paragraph 6.
Geeta Parikh subsequently died.
Yes.
My your lordship had allowed an amendment on the last occasion, and in that order, my lord, as per the order we have amended, your lordship wanted one new affidavit to be filed because your lordship's view was when the cost title is being amended, it's better for new affidavits to come in with the probate application. But all has been done.
So the filing letter.
Joint executors.
Joint executors, at paragraph 8, your lordship will find the legal heirs, wife and 2 sons.
The 2 sons are the executors.
Joint executors. Wife has
Wife
given
has filed the affidavit.
consent.
This is an application for grant of
supplementary affidavit bringing on record the death certificate of the wife of the deceased estate. The supplementary affidavit has been filed and made a part of the records, Lordship. 5th August. It was filed in the department, Lordship. 5th August 2026.
Yes.
Lordship.
You see, my lord, I'm putting petition on. Or in terms of lordship direction, filing the affidavit, my lord, stating that the wife of the deceased has expired due to the pendency of this matter, my lord. I've annexed the death certificate.
Only 2 years.
Only 2 years. One of them expired during
One has expired during pendency of the
Yes,
application,
yes.
which is why filed supplement.
Yes.
Mother and father predeceased, that is there in the petition. This is an application for grant.
This is testator. I'm filing this supplementary.
This is because she died during pendency of the application.
Yes, Lordship.
The others have consented.
Yes, Lordship.
What about mother?
Yes, Your Lordship. It's mentioned in paragraph 7 of the probate petition. She predeceased the testator. Page 5.
Page 5.
Page 5, first line. The mother of the deceased, Srimati Kalavati Devi, died long.
This is an application for grant of probate of the last will and testament dated February.
My lord, the deceased testatrix, before passing off, she had left behind a will along with a codicil. Under the terms of the will, she had bequeathed her properties to some other persons, but she changed the executorship also under the codicil along with the beneficiaries. Now she has bequeathed all her assets and properties, including all her investments, in favor of Ramakrishna Mission Shebashram and different organizations like Sharoda Devi Shangho and Ramakrishna Mission Mott at Coimbatore, Jamtara, and different other places. Now, pursuant to the order of this Honorable Court, which was passed lastly on 11th of September 2024, there was a paper publication both in Telegraph and also one in Anandabajar Potrika. So that has been complied with. I'm told that the
There
affidavit
is
is
no
already.
caveat certificate issued.
Yes. So everything has been complied with, only now the grant has to be given effect to. The registered will was dated 24th of September 2003, which is Annexure B. Thereunder, two of the executors, joint executors, were the brother and sister-in-law of the deceased testatrix, James Michael Lindor and Mrs. Pervin Lindor. And thereafter, your lordship will find that in that will, the testing witnesses were Prabir Chandra Ghosh and Shamar Kumar Dotto, one of whom have given a declaration before your lordship, that is Annexure D. Then your lordship will see that the death certificate, which is Annexure A, dated 13th of December 2021 of the deceased testatrix, followed by the codicil, which is Annexure C, dated 8th of February 2008. These are all registered instruments, your lordship. Now, under the codicil, the Executor has been substituted and a sole executor was appointed, one Shibu Das. The testatrix's husband, Binoy Kumar Guho, predeceased her, and there was no other legal heir who could have raised any objection with regard to the grant. Now, Your Lordship, everything has been recorded in paragraph number 4 of the petition, and the affidavit of
So both
assets.
the will as well as the codicils have been proved by one of the attesting witnesses.
Yes, one in respect of both. In case of the codicil, I find one Shoilendra Narayan Patrabhatto had given his declaration. That is also forming part of Annexure D.
Very well. लिखे नहीं. This is an application for grant of probate.
To be the husband of the testatrix and also setting mallet, he has died issueless. It was already mentioned in the will, but I have highlighted supplementary affidavit stating that mallet. And in paragraph 8 also I have stated mallet, the father and mother of the testatrix had predeceased mallet. It was also mentioned in paragraph 8. Remaining one, remaining is the legal year mallet, give consent mallet. It was mentioned in mallet, my petition mallet. That also
Supplementary affidavit paragraph number 2 to 3. Okay.
For the propounder, last occasion, one thing has fallen from your lordship. Like why these affidavits are affirmed before the notary public, not before this honorable court. As I am informed by my advocate on record, my lord, this is a usual practice of this court, and coordinates my bench also accepted it even after the pandemic situation. My lord, if my lord is so strict on this point, my lord, one thing I can submit. My lord, kindly give me liberty to file an application wherein I can seek a liberty to file fresh affidavits which will be affirmed before this honorable oath commissioner.
Not required. The we have seen Justice Nizamuddin's judgment in 2022. He had passed a judgment in a writ petition saying that no notarial affidavit will be accepted unless certain criteria are fulfilled, where the Aadhaar card or registration number, etc., were required to be put by the advocate who was identifying the person concerned. 2022 judgment.
2022.
Yes. Then, I know. That was a judicial order, it administrative order. That was a judicial order, it was administrative. It is not that the affidavits are not acceptable, but the affidavits have to be in the form which this consents an Aadhaar card, we can proceed with it.
Yes, ma'am.
But if the affidavits are without that, it will be difficult.
There is Aadhaar card.
Go through the order of Justice Nizamuddin.
Yes, my lord, that I can do, my lord. But in respect of my petition, my lord, every affidavit wherein annexed A is a Aadhaar card. I have annexed.
Very well. এটা রেখে দিন, এতে ফেরত দিয়ে দিন, এটা কিছু লাভ হবে না। জুডিশিয়াল অর্ডার যখন আছে তখন অ্যাডমিনিস্ট্রেটিভ অর্ডার কিছু লাভ। Yes.
May I proceed, my lord? Son is the
Yes, yes.
executor, my lord. Son is the executor. There are two other legal heirs, husband of the deceased and the unmarried daughter of the deceased.
They have all consented.
My lord? Yes,
Have
my
all
lord. Yes,
consented?
my lord. Yes, my lord. And attesting witness? He has also Mr. Vilas Bowell has filed his affidavit of attesting witness as well as declaration.
Can it?
Yes. Petition with letters of administration without will. On the last occasion, the matter was notarized, madam. Or the affidavits are notarized, madam. The Lordship referred one of the judgments of Justice Nizamuddin. All the legal heirs have consented, madam. I've obtained a notification from the.
That notification will not help if there is a judicial order and it is not in terms of the judicial order. Right. Here also, since there is an Aadhaar card, I can accept it. Otherwise, I would not help. That will not help. Please go through the judicial order of 2022. You will understand. It was a direction to the departments as well as to the subordinate courts where affidavits are accepted. That without it, it will not be accepted.
Other card, madam. I have annexed other cards, madam. Together with the photo.
Yes. Letter of administration.
Administration without will. Without will, madam. Or the legal heirs have consented, madam. Have given consent affidavits, madam.
All have consented. All have consented.
Yes, yes, madam. It's in paragraph number 2, madam.
is an application for grant of letters of administration in respect of the estate left behind by the deceased.
Administration on the last day I was seeking dispensation of the personal bond by furnishing. Lordship, I'll hand up the judgments passed by this honorable court, Your Lordship. The two judgments, one by the not single judge, followed by division bench judgment, Your Lordship.
What is the difficulty that you have pleaded in the application?
Lordship, difficulty not pleaded in the application because the application has to be formatted, Lordship.
There was a difficulty pleaded there. The first judgment that they have shown.
Yes.
that
Actually,
suffering from kidney ailment has to
yes.
undergo dialysis.
Actually, mother and two brothers, and the only property is the cooperative flat, Your Lordship. So they are not in much position to arrange for sureties for personal bond, Lordship.
What is the value?
Lordship, value is 50 lakhs, Your Lordship. The affidavit of asset, the only property of which its value is that flat, Your Lordship, the cooperative flat, Your Lordship.
देखिए इतने 50,39,000.
Yes, that is only because of that cooperative flat in the cooperative society, Your Lordship.
Very well, not today. I'll consider tomorrow.
Deeply obliged, Lordship. Deeply obliged.
Yes.
Grateful, Your Lordship.
Next.
This is my application for grant of letter of administration. All the legals has given their consent as to the grant of letter of administration. In paragraphs 4, we have stated the details of the legal aids.
Mother?
But we have pleaded in paragraph 4. The mother has predeceased the deceased person. We have pleaded in paragraph 4.
Where?
Paragraph 4 of my application.
Yes.
Just above this one. The details of the
Paragraph
particular
mother
in handwriting. There.
The others have consented.
Yes, everyone has given their consent.
After the death of the legal heirs after the death of the deceased Mohit Agarwal is his mother Asha Agarwal, his wife Vandana Agarwal, his minor son and daughter Tanish and Devanshi Agarwal.
Mother has affirmed affidavit of
On-
consent on behalf of the minors also.
Yes, Lordship.
Show me that once.
Lordship comes to page 33.
Page
33. Paragraph 1, Lordship, it reads,
The will mother has any adverse interest to the sons and daughters, or all of them have?
all of them have consented.
them have.
Yes, Lordship. It's just that on behalf of the minor, the mother has also,
And what about the mother of the deceased?
the mother of the deceased has also given consent, Lordship. If your Lordship takes up page 26. Asha Agarwal, Lordship.
Which page is the will? Where is the will?
Sorry, Lordship.
Where is the will?
The will is annexure A, Lordship,
Yes, got it.
page 10.
There is a problem. You see paragraph 3. That is why I put this question.
Yes, Lordship.
Shall devolve only on the wife to the exclusion of the legal heirs, which means the son and daughter are excluded, they are minors. So if she is filing affidavit of consent on behalf of the minors, she is in a sense, if I exclude this, her being a mother, is she not acting adverse to the interest of the minors?
Lordship, in that case,
There is a 1930 judgment of our court. Please consider this, enlighten me on this, whether this can be done.
very well.
There is a
Lordship.
clash. The mother is waiving the interest of the minors, which minors may or may not have agreed to if they were majors. Nobody knows. Because it's on consent.
Yes, Lordship.
Where they do not have the capacity to grant consent. They are consenting through their natural guardian, who has the entirety of it, and they don't.
Very well, Lordship.
Be beyond suspicion when it is non-contentious.
Very well, Lordship. I shall satisfy your Lordship. Just permit me.
Consider on this. Consider on this and come back.
Grateful.
When do you want to come back?
2 days later, Lordship.
Not this week I'm making it. Come back on Monday. Which is why I said read the will.
Yes.
Thank you. Next.
This is my application, my lord, for grant of letters of administration. Lordship will recall, my lord, on the last occasion, my lord, I moved the matter only on that point of surety, my lord. Your Lordship had, my lord, adjourned it, asked us to take instructions and come back on the point. My lord, the applicant is the sole legal heir. The mother of the applicant, who is the wife of the, my lord, the deceased has passed away. Admittedly, that's been pleaded in my application. And the mother of the deceased, my lord, also a class 1 legal heir, has, my lord, predeceased the deceased. So, my lord, that person is also gone. My lord, the valuation of the shares, my lord, which is schedule A to my application, my lord, kindly takes up, my lord. That, my lord, amounts to approximately, my lord, 6 crores 79 lakhs 44,000. My lord, the only thing that was troubling your lordship on the last occasion, my lord, was that point with respect to, my lord, the surety that we had, my lord, made in my award in my prayer, was that we were, my lord, paying a personal bond, my lord, of 10 lakh rupees. But I've taken instructions on this specific point, my lord, from the client. But they are, my lord, ready and willing to pay, my lord, the 10% that have fallen, my lord, of that amount. My lord, they are. But there was one judgment, I had taken it out earlier, my lord, Justice Rao's coordinate bench, but it's a sole legal and they were not required to, my lord, pay. Otherwise, it becomes an onerous burden. But possibly because of the instruction, I don't need to place that before your lordship anymore. But there is, my lord, otherwise the judgment. It's a sole legal. In that case, it was a class 2 legal. Because the class 1 legal was not available, where the requirement of that the bond, or the administrative bond, that was dispensed with.
Give me that judgment, will help me later.
No, this I was carrying. Hopefully, my lord, this is not too far from the facts of my case. So, lordship only takes up, my lord, this penultimate page, my lord, paragraph 13, at page number 10. Now, this is possibly the only paragraph that I need to show without wasting my lord's time, my lord.
Yes.
Your lordship wants to, my lord, consider this. I have, my lord, candidly presented whatever my instruction is. My lord, we'll bow down to whatever my lord decides.
We'll go by what your instructions are.
Very well, my lord. Very well.
We'll keep this for arraign's
Yes,
sake.
yes.
This is an application for grant of letters of administration.
The tester is before your lordship died on 26 February 2009. 2009. The tester is executed the will on 2009, 1995. There were 3 executors. Out of 3, 2 have died already prior to the death of the testatrix. The remaining executor, Mr. Monisha, is applying before your lordship. Your lordship will get the will as Annexure A. Will is dated 20th October 1995. And the death certificate is that is being enhanced. And death certificate is death certificate of Mrs. Roma Bose, died on 26 December 2009. Attesting witness affidavit, your lordship will find just little later after the affidavit of assents. And the other remaining years, they were served.
About the husband of the testatrix?
Beg your pardon?
Husband of the testatrix?
He predeceased the lady, the testatrix.
Where do I find that?
That in the death certificate itself. In your lordship has got the death certificate?
Yes.
E.K. Bose, Dhruvo Kumar Bose.
Page 3 it is mentioned. Very well.
Your lordship will find a citation report of the sheriff office.
What about the other attesting witnesses? They, other
They have
heirs,
not
they have
come
not consented.
They have not come forward to support the probate application, but they have been served already, because your lordship will
No
find it
caveat issue.
in the mode of service of the deputy sheriff of this court. The first, Mr. Siddhartha Bose and Sriporna Bose, we have received the citation, and the last one,
Sharmila Ghosh.
Sharmila Ghosh has received. If your lordship is kind enough to read the last line of the
at a different address. This is an application for grant of
My lord, this is my application, my lord, for grant of probate. My lord, the testatrix, my lord, died on 13th August 2024. And before that, on 17th of September 2022, she executed a will whereby she appointed General Secretary Ramakrishna Mission as the sole executor of the will. And he bequeathed his entire property to the Ramakrishna Mission, Belur Math. The testatrix has no issue, my lord, and his husband predeceased the deceased. I have stated in paragraph 6, my lord, of my petition. It appears from the said will that the
Is that to call item number 36?
Not now. Lordship, regarding item number 5, when it's called, I am on my legs in scat. My lord, it's making not today. Kindly make it not this week.
Made it not this week only, not today.
Item, please, because the conducting advocate is
Only.
not this week. Much obliged.
We have a lot of matters now. Tomorrow.